Did we do this one first?
All right, I'll let you do it today, but
And then I can
tomorrow,
just
yes,
so-
okay.
Okay. Thank you.
All right, so let me hear from you all on what I'm prepared to do is hear the motion on excluding late filed witnesses and then going into the motions in limine, and we can do state defense, state defense. What do you all want to do?
That's fine with the defense. I think many of the motions hopefully will be far shorter, and some of these issues, I think, have somewhat been dealt with briefing, because as much time today as can be spent on things to make sure we have an orderly and good trial, I think are helpful. Some of those were raised in the middle and some were not, so that's a fine system, and we're going to hope, at least on the defense side, to move quicker.
Okay. All right, so let's take up okay, State of New Mexico's amended expedited motion to exclude defense witnesses Ryan Winterstern and Christopher Zook. You can use the lectern or you can, yes.
You might want to turn that microphone on.
And just so you know, so everybody knows, if you have a green light, that means your microphone's on, and if you don't want anybody to hear what you're saying, you want to turn that off.
May I proceed, Your Honor?
Yes.
Your Honor, the state filed this motion on June 26, 2024, after the defense disclosed on June 24th a witness by the name of Ryan Winterstern, and I understand he is one of the producers of this film. Mr. Winterstern had not been disclosed by the defense on any of their witness lists prior to June 24th. And while they argue that the state had Mr. Winterstern on its witness list in the Hannah Gutierrez trial, we would respectfully submit that that's a different issue. So here, the state did not have Mr. Winterstern as a witness. And so we understand that the defense is claiming that the reason they added him is because the state at the last minute added this producer theory. However, as the court, I think, noted in one of the hearings that we had previously, this producer issue was known to the defense. And in fact, during the grand jury presentation, and it begins at page 186 of the grand jury transcript, Ms. Morrissey questions the state's expert, Brian Carpenter, about Mr. Baldwin's role as a producer. And so this is not something that was new to the defense. Under State versus Lemire and State versus Sanders, the state is asking the court to exclude Mr. Winterstern because, number one, we have not been provided with the statement that he is going to be making or has made. We didn't have an opportunity to do a pretrial interview of Mr. Winterstern. So as it relates to this case, the state has no idea what he is going to be testifying about or any previous statements that he made relating to this particular case. Setting Gutierrez trial aside, the issue is, what is he going to say in this case? And because of the late nature of this disclosure, we'd ask that the court exclude Mr. Winterstern. With regard to Mr. Zook, now, while the defense is right, the state did not request pretrial interviews of law enforcement witnesses. They were made available. Mr. Zook was set for a pretrial interview, but apparently he has left the sheriff's department, so the defense canceled his subpoena and did not proceed with the pretrial interview. So he was not interviewed. We would respectfully ask that because of the fact that the state has not interviewed these witnesses, and particularly Mr. Winterstern was disclosed so late in the game, we ask that the court exclude these witnesses. And unless the court has any questions, Your Honor, we rest on the motion.
The court does not. Thank you.
Thank you.
Good morning, Your Honor.
Morning.
So we'll start first with Christopher Zook. As the state has already conceded, the state did not actually request a pretrial interview of Mr. Zook. It is something that they do have to request. The defense did set up an interview that was for our own benefit. We did inform the state that we had set the interview so that as a courtesy, they could come if they wanted to, but it was not something that they requested. And if the party does not request the interview, then it is deemed waived. And at any point, they had an opportunity to do so. I do have an exhibit to provide to the court. I also have a copy for the state. And so I do have an exhibit A, which is to this motion, if I may approach, Your Honor. And what I've presented the court with is a series of emails that were exchanged between the parties. And these begin with the request that the state made for witness interviews in this case. And as the court can see, and as the state has already conceded, Mr. Zook is absent from their request. Now, the reason we've included these additional emails as well is because there were multiple occasions on which the defense actually asked the state if they wanted to amend or add any additional witnesses for whom they wanted to request pretrial interviews. At no time did the state then change their mind and say, yes, we want to interview Mr. Zook. And so that was deemed waived, Your Honor. And we canceled the pretrial interview that we had set for our own benefit for our own reasons. And so the state cannot now seek to exclude him when they did not take advantage of the process that was available to him. Additionally, with respect to Ryan Winterstern, it is somewhat ironic that in their motion, the state claims that the defense recently added Mr. Winterstern to gain some sort of tactical advantage, when really what we have here is that type of behavior on the part of the state. And one of the ways that we see this is that with respect to the initial filings before there was a dismissal in this case, when the case was originally brought before the court against Mr. Baldwin, originally, it had been clear that the previous prosecution team had intended to produce and to pursue a theory that involved liability based on a producer theory on Mr. Baldwin's alleged role as a producer. Based on that, we also then had a conversation with the new prosecution when they took over through Ms. Morrissey. And a conversation was had about the producer theory. And that was gone into in-depth and private conversations, at which point in time, Ms. Morrissey indicated that she did not believe that that had that could hold any water, that it was a viable theory. Later, certainly there was the grand jury presentation. Now, there was really not much of anything related to Mr. Baldwin being a producer. They didn't call anyone who was on the set. There were a number of different producers. I believe it was 6 different producers who were actually on the Rust set. They didn't call a single one to testify. And so it was not clear to the defense. And the fact that it was unclear to the defense is apparent in the fact that we have an additional exhibit, Your Honor, if I may approach. And the exhibit that I've just now handed to the court, which would be then exhibit B to this response, is an email correspondence between, again, the state and the defense, wherein, as the court can see, and I think the court will have to flip to the back page to see the beginning of the chain. And so on November 1st of 2023, the defense inquires and says, your target notice identifies 2 involuntary manslaughter charges on which you will be presenting information to the grand jury. We then proceed to ask that in order to ensure that the alert letter that we submit actually is efficient, that we don't waste everyone's time, that they identify the 2 theories that they're going to be proceeding on. The state through Ms. Morrissey then responded, basically just reciting the statute. We then asked and followed up on that to say, we assume that the producer theory is not going to have merit, and so you're not proceeding under that theory. There was no response. The state easily could have responded, could have let us know. They knew where our mind was. They knew that we were thinking, because of the prior conversations that we had had with Ms. Morrissey, that this was not a theory that they were going to proceed under. Additionally, Your Honor, with respect to the witnesses that they've listed in the actual case itself, And this again goes beyond just the grand jury. In the case itself, the state has not listed a single one of the producers who were on the Rust film, not a single one. And so at this point, they have 3 different individuals who they're going to call to try to have them testify about what Mr. Baldwin's role as a producer would be on this film, what responsibilities he would have. 2 of those individuals have never been a producer before, and the other individual has very limited experience and was not actually on this set. So we sought, after the state had then disclosed basically for the first time to us their intent to proceed under this additional theory through some of the motion practice when we filed a motion unrelated to one of their witnesses. They then first identified that they were going to move under this new theory. So we then, just a matter of days later, added Mr. Winterstern to the witness list, and it was for the first time. But this was because the defense was not on notice that they had intended to pursue this theory. And he was not on the witness list to try to gain some kind of tactical advantage. It was because he wasn't relevant due to anything previously that we understood the case to be about, which was, again, according to the indictment as well, it specifically lists the date of being October 21st, 2021. It does not list a series of dates. It doesn't list the length of time that Mr. Baldwin was on set. It lists one particular date. And so Mr. Winterstern was not relevant to the defense theory at that time. However, now we have added Mr. Winterstern, and the state cannot claim prejudice because Mr. Winterstern was a witness in Hannah's trial, and I'm almost finished, Your Honor. But not only that, he was the state's witness, and they did conduct a pretrial interview of Mr. Winterstern. And during that pretrial interview, it was actually asked by Ms. Morrissey what Mr. Winterstern's role was as a producer.
When was this pretrial interview?
This pretrial interview, Your Honor, that I have was January 8th of 2024. And so January 8th of 2024, he was asked a number of questions about his role as a producer by Ms. Morrissey. Ms. Morrissey also asked Mr. Winterstern about other producers' roles. Ms. Morrissey also asked about Alec Baldwin's role as a producer on set. And this is someone who would have personal knowledge of that, unlike any of the other witnesses that the state is calling to try to make out this producer theory. So there is zero prejudice to the state because everything that we would be going into in the trial has already been covered by Ms. Morrissey in their own pretrial interview for a witness whom they called in the previous trial. And so we understand that they're now trying to claim prejudice, but it's because that they know that this sinks their claim and that this is a much more appropriate witness than any of the 3 whom they've listed to try to go after Mr. Baldwin on this producer theory. So we ask, Judge, we are just asking for basic fairness and due process. There are other avenues. If the court wanted to give them another interview, they could do that. But again, they've already had a substantive interview of him, and we would ask that the court allow Mr. Baldwin to present this defense.
Thank you. Reply?
Yes, Your Honor. Thank you. Your Honor, the issue is the court issued a scheduling order in this case, not in the Gutierrez case, in this case. The court set deadlines for pretrial interviews. It set deadline for witness disclosures. And the fact that Mr. Winterstern was interviewed in the Gutierrez trial does not obviate the need to have a pretrial interview of him in this case, because in Gutierrez, he was listed as a witness for the state. In this case, the defense is calling him. The state has no idea what he is going to be testifying about. The state has not been given any prior statements as it relates to this case. And as the court can see, Your Honor, what we have here is by this email is that the defense was put on notice, and they call it a producer theory. It's really not an independent theory of liability. What this evidence goes to, it goes to Mr. Baldwin's knowledge that his conduct on set was reckless, and it was in essentially wanton disregard for the safety of others. And his role as a producer made him keenly aware of the safety rules that apply on sets, what his responsibilities are. And so, as we'll argue in the 404 or the intrinsic evidence motion, This particular type of evidence is germane to the defendant's recklessness in order for the state to prove the involuntary manslaughter. They cannot claim that this is a new theory. As I noted, Your Honor, page 186 to 187 of the grand jury transcript, which was attached to the state's June 21st, 2024 response to the defendant's motion to file a supplemental brief, Ms. Morrissey goes into great detail with Mr. Carpenter, the state's expert, about Mr. Baldwin's role as a producer, his responsibilities as a producer. Mr. Winterstern, from what we understand, has very little producer experience, but nevertheless, we would argue to the court, Your Honor, is what is he going to be testifying to in this case? The state has no idea. That Ms. Morrissey spoke to him in the context of the Gutierrez trial is irrelevant to the court's analysis in this case. Under Lemire and under Sanders, and in Sanders, it's 1994 New Mexico Supreme Court 43 at paragraph 26. The court noted a defendant's right to present evidence on his own behalf is subject to compliance with established rules of procedure and evidence designed to assure both fairness and reliability in the ascertainment of guilt or innocence. If the state had done this, you know they'd be up here screaming to the court that we have sandbagged the defense. Your Honor, the state is entitled to a fair trial as well. And so we'd ask that the court exclude Mr. Winterstern. Thank you.
All right, the court makes the following ruling. The court denies the state's motion. With respect to Mr. Well, first, with respect to both of them, I don't think that you've established prejudice, and to the extent that you want them excluded, certainly there are other remedies. I will have the defense make Mr. Lingerstein available for a pretrial interview. And with respect to Zook, I'm not quite sure now. They're saying they want an interview. All right. Is that a problem for you?
You can confer with the state and work out the issue.
All right. Thank you. All right. Remember, I believe it's 10 minutes aside, half an hour for lunch. So I'll start with one of these. All right, state's motion in limine to exclude evidence or separate civil suits against defendant and or Rust Productions. And if you're going to do a reply, you're going to need to figure out how you're going to do that. 3 minutes for the reply.
Thank you.
Okay.
I'll be brief. This one's
And
not
I hate to tell you, I'm going to cut you off right away. Okay.
understood. Your Honor, in this particular case, as the court is aware, there have been multiple civil lawsuits filed against Rust Production and against the defendant himself. Mr. Joel Souza, one of the state's witnesses, filed a civil lawsuit that I understand, has since been settled. There are 3 other states' witnesses, or 4, I believe, other states' witnesses who have pending civil lawsuits. We would respectfully ask that the court preclude the defense from cross-examining first Mr. Souza about his settled civil lawsuit. And there's a case right on point, which I cited in the motion, which is United States versus Whitehead. It's a U.S. 10th Circuit Court of Appeals decision, 562 Federal Appendix at 701, wherein the court affirmed the district court's denial of cross-examination on a civil lawsuit that was related to the criminal case, but that had since been settled before the criminal case went forward. And that's the issue with regard to Mr. Souza. The fact that he had a civil lawsuit and settled it is irrelevant and should not be allowed. With regard to the other witnesses, Your Honor, although we understand and the state acknowledges that under State versus Santillanes, the court noted that the pendency of a civil action by prosecuting witnesses seeking damages is a proper subject of inquiry. But the court also recognized that it's proper if the civil action is for the same offense that is being tried. And that's where the state respectfully submits there is a distinction between the pending civil lawsuits that 4 of the state's witnesses have versus what the court looked at in Santillanes. My understanding is that the pending civil lawsuits that the 4 states' witnesses have to do with intentional infliction of emotional distress and negligence as a whole in the filming or during the time that this filming was taking place between October 6th and October 21 of 2021. So it's not specifically related to the charge that the defendant is facing. Now, if someone had a pending wrongful death lawsuit, I would concede that that is germane and is subject to cross-examination. But because there is a difference between the civil lawsuits and this pending criminal prosecution, we would respectfully request that the court deny or preclude the defense from questioning these witnesses about their pending civil lawsuits, unless the court has any questions, Your Honor. Thank you.
Your Honor, the defense has no present intention of questioning Mr. Souza about his settled lawsuit. I'm not waiving that issue, but I don't think the court needs to get there today. The rest of this issue is quite easy. This cross-examination was done during the Armour's trial, as the court no doubt remembers. In that case, there was zero financial motive. In this case, there is a suits against Mr. Baldwin directly, an extreme financial motive. And number 3, the lawsuits are exactly on point. It almost actually looks, if you look at the lawsuits versus the state's case, like they copied and pasted it. And I know this case seems in some ways like a civil negligence case, but it literally looks like they may have copied and pasted part of the lawsuits. So they're directly on point. None of their cases say what they claim. The case law on this is clear. It's actually one of those issues that's universal amongst all 50 states and all courtrooms in this country. You can always cross-examine a witness about their motive and bias. You can always ask them if that's the reason they're testifying in a certain way. And that's what the confrontation clause promises us, and that's what the Constitution demands. I have nothing further.
Any reply?
Just very briefly.
Your Honor, it's a fine distinction, and it's made in State versus Santillanes. If the civil action, and I quote, was for the same offense being tried in a criminal action, absolutely agree, it would be subject for cross-examination. But I would respectfully submit that there are differences here between the civil actions and this criminal prosecution. So we'd ask that the court preclude any cross-examination.
All right, the court makes the following ruling. Evidence of pending lawsuits against defendant by testifying prosecution witnesses is proper impeachment evidence. The motion is denied. All right, next up is defendant Alec Baldwin's motion in limine to preclude improper impeachment evidence. Is that what you all have as the next one? Or was that at the end?
Is there a number?
Is it
Well,
Baldwin?
that's the problem. In the beginning, you didn't number.
That's my fault. I'll take responsibility for all faults to date.
Okay, so you want to do these at the end, and you want to start with what do you want to do?
I'm happy to do motion, what looks to me like motion eliminate 1 from
Okay,
the-
we'll do
the
these other
defense.
ones later. All right. Defendant Alec Baldwin's motion in limine to preclude improper prosecutorial conduct and require an orderly trial.
And yes, Your Honor, I think this is a good place to start today, because this is sort of my main issue throughout the day and what I'm going to ask to address at various points. And that's why I'm going to keep my remarks so brief on my motions, because hopefully the court will give me the courtesy of a few more minutes when I need at the end. But essentially, the court has the papers. Their response that the state is allowed to burden shift in certain places, that's their sort of strongest response, misses the mark. I mean, even in the case they cite, right, what the prosecutor does, it's one remark in summation where the prosecutor says, I, of course, have the burden of proof. It never leaves this table. This is a very serious proceeding, and I have the burden of proof. Just so you know, though, you can consider, and then they make one remark. That's the context of any case that goes against these basic propositions that are also the same in every single state in this country. So the reason that I had to make this motion is because in reviewing some of the trial, and I haven't been able to get through every bit of it that I want to on this subject, but it's constant issues with controlling the prosecution from doing things that are just straight and proper. And so I don't know what to do in that circumstance. I've never made a motion like this before, but it's objection. This witness doesn't know that. Objection. They don't know how to identify the picture. We have plenty of other witnesses. Sometimes it was no objection at all. Sometimes the prosecutor just called out from the prosecution table and started saying, I would request the witness read the entire transcript. He can't answer that. And then there's the questions, and we'll get to this in another mill, which is constantly, every single witness, they'd ask a question, what happened next? And where was Miss Hutchins during that? Where was Miss Hutchins? Oh, she was in the helicopter. And then they would go on. And they would ask another question about the chronology. And they say, well, where's Miss Hutchins? She's in the helicopter. And so, this is, it's misconduct. You can't do that. You can't do that as a prosecutor. You're not allowed to do that as a prosecutor. It's very serious to do that as a prosecutor. And so eventually the court at some point stopped Miss Morrissey from doing the coaching, speaking objections. And then Miss Morrissey began, every time her name was mentioned in a question, she began to stand up and say, well, I'm being talked about in this question. And she began interrupting the proceedings. So I didn't know how to address this. I don't know how to address this, even as I stand before Your Honor. But my request would be objection, relevance, objection, hearsay, and nothing else. And in the very rare circumstance when an issue rises to the level of extreme importance or constitutional imprint, a lawyer can approach. If there's something very complicated, a lawyer can approach. But otherwise, none of those tactics and devices should be used at this trial. We've come a long way to get here. The court has been very patient. All that we want is a fair trial. And for the rest of this, I would rely on my papers. Thank you.
Response.
Thank you, Your Honor.
Your Honor, I think we can agree on one thing, absolutely, without a doubt, and that's beyond dispute. The state has the burden, and the state cannot shift that burden to the defendant. Absolutely agree. However, there are those limited circumstances where the state is given latitude with regard to countering defendant's arguments. For example, the defendant comes in and, as the court has heard, presents argument that somehow somebody modified this firearm. Where is that evidence? The state should be allowed, and it has been allowed, and in fact, in State versus Aguayo, which is cited in the motion, 1992, New Mexico Court of Appeals 124, the courts have allowed the prosecution to argue that the defense didn't present witnesses to support their defense theory, but the state has the burden. There's no question about that. So we would ask that the court give the state some latitude with regard to responding to defendant's arguments. And I can guarantee you, we will not, the state will not, under any circumstances, shift the burden to the defendant, because that's improper and it will not happen. With regard to vouching for opinion or for witnesses, I agree it is improper to vouch for a witness's credibility. But there are circumstances, Your Honor, where the state is permitted to comment on the veracity of a witness as long as it's based on evidence. If the prosecution says, it's my opinion that this witness was truthful, absolutely improper, absolutely agree. But if it's based on evidence that a witness testified to X and there's corroborating evidence of X, the state is allowed and should be allowed to argue to the jury that this witness has testified truthfully based on the evidence. And finally, part of this, during closing argument, Your Honor. Yes, no, not during trial. With regard to coaching witnesses, Your Honor, which is the last part of this motion, I agree as well. A prosecutor must not coach a witness, particularly must not coach a witness to testify falsely or to phrase the witness's testimony. However, it is absolutely proper for the prosecution to meet with witnesses, to prepare to testify. The defense has taken the position, I believe, that any sort of preparation with witnesses is improper. I would ask that the court not allow the defense to try to imply to the jury that meeting with witnesses prior to their testimony is improper. Coaching, absolutely. That the prosecution to tell a witness what to say, absolutely agree. But to meet, to prepare for their testimony is completely proper. And we'd ask that the court not allow the defense to comment on that as being improper. Thank you.
Anything else?
No, Your Honor.
All right. Well, I have to say, I don't like these kind of motions because I'm not going to be bound by it during trial where someone shows me an order and says, this is what I said. I was going to tell you, but I'll tell you now, based upon the ruling, every time you want to say something that is not a question to your witness, you're going to come up to the bench. So you do not get to say objection, blah, 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 and then wait for me to say to come up. You're going to come up. And this happened in the Hannah Gutierrez trial. So.
Yeah, I just point of clarification. I don't have any intention of approaching during the trial other than the rarest of circumstances.
No. You have to come up to the bench and put on the record your objection. You don't get to do it from there.
Okay, I have to internalize this. I've never had a trial conducted that way, so I would ask to potentially address this issue. I mean, I don't think the defense or anything that I've done would necessitate changing the rules. At least I would ask that
This is a court can do what they want with respect to objections, and this is what I'm going to rule. So I'm trying to the sides have been contentious with one another. I think that you all may not intend to, but you might want to try to get the jury to see what's wrong with that question and or make some argument to try to influence the jury. And if you're going to object, it's going to be up here, and you're going to put on the record what the objection is, and I'll make a ruling up here.
And may I just approach for just
Yes.
a second? So I'm glad I saved my rebuttal because I do want to address this issue, Your Honor. What I would ask and urge the court, because I think that this system could disrupt the ability to cross-examine and disrupt the defense. It is not, as I think the court will acknowledge, it is true, the court has great discretion. I think that deciding that before the trial even begins is an extreme use of discretion, just genuinely. I know that issue happened at the prior trial. I'm asking and urging the court to give an opportunity, at least to the defense, to just simply say, and I think my suggestion works, right? It's just objection, relevance. There's no other words coming out of my mouth ever during objections at a trial in front of the jury, and to allow us to have an opportunity to have what I would call a normal procedure. Because if every time there's any progress going on with a witness, they're standing up and they're making everybody come to the bench, they're disrupting the ability to cross-examine. They're disrupting the ability to put on our case. So what I would urge the court and ask the court to please do is to allow us, at least, if after the first witness, even the court wants to revert to what they did later on in the Hannah Gutierrez retrial. But I can tell the court I've tried many, many cases. I've never had that issue before. I've never had that issue with one witness in one case. So I'm asking the court to at least give the parties a chance to do it. I also am very concerned about the time, schedule, and everything else. There are lots of objections that are just objection relevance. The court will rule. If the court needs to hear more, we come up. And I'm urging, almost begging the court to at least let us start that way. And then the court can, like this, and not hear from me further on this issue. Thank you.
I'm not going to change my mind. I can see what I want to do is I want to start with you all getting the lay of the land. And I'm going to be in control of the courtroom. So this is what I'm going to do. I'm sorry that you haven't experienced this because it can happen, and it does happen. So that's what I'm going to do. If you all seem to be doing well and you get it, and I'm hearing relevance, I agree, then we can perhaps relax the rule. But that's how it's going to start off. Okay? All right. So I don't know what I basically didn't really rule except that I'm in control of the courtroom. All right. Thank you. All right, next up is state's motion in limine 2 to exclude UNM hospital records of Ms. Hutchins' medical treatment.
Your Honor, we have no present intention of admitting this exhibit. I don't think there's any grounds to exclude it based on redactions, but this case isn't about the medical issues of Ms. Hutchins, and we're going to address these issues in a
All right,
in
so
another bill.
what is the bottom line? You are no objection?
No objection, Your Honor.
All right, no objection. Let me just write this down. All right, so the motion is granted. All right, defendant's motion limiting number 2 to preclude inadmissible character and prior evidence and statements unrelated to the events of October 21, 2021.
Good morning, Your Honor. It's nice to finally see you in person. Thank you. So I'll be brief. You just heard Ms. Johnson, in response to our arguments about the civil suits, say the civil cases are about October 6th to October 21st, the whole negligence. And that's very different from what Mr. Baldwin has been charged with. He's been charged with what happened on October 21st. And yet, when you look at the 404B disclosures that the state has provided, all of those disclosures relate to events that happened before October 21st. Mr. Baldwin swore on set. He cussed. And therefore, what? He committed homicide? Mr. Baldwin pointed the gun earlier or rushed people earlier. And therefore, on October 21st, he had a propensity to do it again, or he committed homicide. That's exactly the kind of propensity evidence that must be excluded, Your Honor. The state cites 3 cases about this. The first one, all of them illustrate it, but the first one illustrates it best. The US v. Reggio case. They say Reggio was a commercial trucking driver, and the state was allowed to introduce evidence of what he did before the commercial trucking accident that he was involved in. But when you look at the case, what actually happened was Reggio had a medical condition. His doctor diagnosed him with it. He went and he applied for his commercial trucking license, and he denied having the physical condition. He knew that condition made it unsafe for him to drive. He got his license, procured by that lie. He drove, he got in an accident, and someone died. And he was charged with involuntary manslaughter based on an unlawful act that he committed before. What was that unlawful act? He was driving knowing that he wasn't physically qualified. That was the predicate act. So the state said, we're going to admit evidence of that predicate act. He lied to get his commercial trucking license. And that's going to show, A, the predicate act. It's also going to show he knew it was dangerous for him to drive. And they were going to bring the doctor in there to say so. That's not at all what's happening here. Mr. Baldwin swearing on October 16th is not a predicate act. It's not a crime at all. Whether he checked the gun or not on October 16th, not a predicate act. And so the cases that they cite, starting with Reggio, have nothing to do with how they're trying to use the evidence here. Now, it might be different if they said, look at Mr. Baldwin on October 16th. Look what happened. He was rushing people. He was pointing the gun. He was doing all these crazy things on set. And look what happened. There was an accident. Someone got hurt on the 16th. And he knew it was dangerous to do what he was doing, yet he continued to act on the 21st in the same way, knowing that harm happened before. That might be relevant, but that's not what happened here. No one was injured because he swore at someone on the 16th or threw a gun on the ground on the 16th. They're trying to use it to show propensity. Reckless before, reckless now. They cite 2 other cases, the Coughlin Lambert cases. Coughlin, they say, the court allowed the government to introduce evidence of his prior athletic activities when he had submitted a victim's compensation claim after being injured at 9/11. The state says, see, look, prior activities, case now about a fraudulent claim, 9/11. But the fraudulent claim charge against him was that he wasn't actually injured at 9/11 as severely as he said he was. Because look at, he's running around, he's an athlete. He's clearly not injured. So that had nothing to do with propensity, had nothing to do with he's a bad guy and therefore he committed fraud on the victim's compensation fund. It was directly relevant to it. Same with the Lambert case. It's a bank robbery case. the defendant was talking about robbing a bank before, planning the locations, plotting it out. And then lo and behold, not so long after, he robs a bank. He says, you can't do that. You can't admit character evidence. The court says, no, you were talking about robbing a bank. And then lo and behold, not so long after, he robs a bank. He says, you can't do that. You can't admit character evidence. The court says, no, you were talking about robbing a bank. You were planning the location. That is directly linked to the fact that you did, according to the state. So all of the cases they cite have a very direct link. The evidence that they're trying to admit against Mr. Baldwin, it's all propensity. Mr. Baldwin's not a murderer on the 21st because he swore on the 16th. They're going to try to show that. That's highly improper. It should be excluded. Thank you, Your Honor.
May I please the court? Your Honor, first, these other acts evidence constitute res justa. This is intrinsic evidence. And I can tell you I'm intimately familiar with the United States versus Riego case because that was my case. Mr. Riego was charged with 4 counts of involuntary manslaughter. And the court allowed the introduction of his prior medical records from about 2 years before the incident happened. So the traffic accident happened on September 7th, 2019. And Mr. Riego was driving on the interstate on a phone call with his wife. And then he unfortunately crashed into the victims and killed 4 people. The court allowed evidence of those medical records and allowed evidence of his application to get his commercial driver's license, where he indicated that there were no medical issues. And also the court noted in allowing this as res justa or intrinsic evidence, that this evidence goes to the defendant's reckless state of mind. So for involuntary manslaughter under the state statute, as the court knows, the state has to prove that the defendant acted without due caution and circumspection. And so we have to prove criminal negligence, that the defendant willfully disregarded the rights and safety of others. And the uniform jury instruction, and it's cited in the Henley opinion, that the defendant should have known of the danger involved in his or her actions and continued to act. So intrinsic evidence is evidence that is directly connected or provides context to the jury of the charged offense, and it's connected to the factual circumstances. So what the defense wants is for the jury to be, for the state to only be allowed to introduce in a vacuum the moments leading up to October 21st, 2021, when the defendant shot Ms. Hutchins. However, intrinsic evidence allows the introduction of evidence that's inextricably intertwined with the acts that form the charged offense. So I would respectfully submit, Your Honor, that this is the state has submitted this notice on June 17th as required, putting the defense on notice that these different videos show the defendant acting in a wanton and reckless manner. For example, there are 8 videos, and those are exhibits 61, 62, 63, 67, 68, 72, 74, and 76, where his finger is on the trigger when it shouldn't be. There are some videos, 7 videos that show the defendant sort of horse playing around with guns, exhibits 95, 111 to 115, and 65. Evidence of the defendant using the gun as a pointer, exhibits 91 and 58. These are inextricably intertwined with what he did on October 21st, when he pointed that gun at Ms. Hutchins, cocked the hammer, and pulled the trigger. And so that prior evidence, those other acts evidence, basically put into context what happened on October 21st and established the recklessness mens rea. In the alternative, and there's another issue, Your Honor. So the defense are going to be arguing to the jury, and we've seen the preview, that this gun was modified and that it didn't work. Again, as intrinsic evidence, these videos show on a number of occasions that this gun was working perfectly fine It had no malfunctions. Every time the defendant fired it, he pulled the trigger. There were no issues. So it is actually relevant to demonstrate that there were no issues with this gun. In the alternative, Your Honor, these other act evidence instances of the defendant's conduct are admissible under Rule 404B to show knowledge and to show lack of mistake. Knowledge in that the defendant should have known on October 21st, when he was pointing that gun at Ms. Hutchins, that his conduct was wanton and reckless. And we prove that by the evidence of the other instances where he acted in a wanton and reckless manner as it relates to this gun. And it also shows that there's no mistake. The defense is going to argue, oh, this gun just discharged on its own. I didn't do anything. This is not a mistake. Each time he had his finger on the trigger, previous occasions when he shouldn't have. And so I would respectfully submit that they are admissible as intrinsic or in the alternative under 404B. Thank you.
Any reply?
Yes, Your Honor. 2 points, Your Honor. Number one, the state told you what it's going to do. It's going to try to show recklessness before and therefore recklessness on October 21st. That's propensity evidence. That is not what Reggio allows, not what Coughlin allows, not what Lambert allows. They cannot do that by showing what happened before is an indication of what happened after. There was no, as I said, aha moment connecting state of mind before to state of mind on the 21st. No accident happened. Reggio, the reason state of mind was inextricably linked was because he lied about his medical condition, knowing he couldn't drive. That's the proof. That was inextricable. It was a predicate act. None of these are. On top of that, most of the clips don't show Mr. Baldwin shooting. They show him swearing or putting a gun on the ground or taking a gun when he's lying on the ground and sort of accidentally pointing it. These issues are not what they're trying to show about the 21st. He's not shooting, showing a malfunctioning gun in most of them. They're trying to bring it all in, not to show what happened on the 21st, but to use it as reckless evidence of before and therefore after. She just told you that, Your Honor. I have nothing further.
All right, thank you. You're going to see me looking at my laptop. That's because I took notes on these matters on my laptop. All right, the court rules and reasons. Evidence regarding defendant's handling or firing of the firearm or firearms firing during the filming of Rust are relevant in that they have any tendency to make a fact more probable, to wit that the firearm worked properly during the filming and that defendant Baldwin was not handling the firearm safely. This goes to facts of consequence in this action. Applying the balancing test in which the court may exclude such relevant evidence of probative value is substantially outweighed by unfair prejudice, confusing the issues, etc. The court balancing test does not weigh in favor of defendant. However, any of the videos or any evidence or pictures which relate to Mr. Baldwin not handling or that goes to the defendant's the gun didn't work, and they're showing that it did work because he's shooting videos that show that he's cocking the gun when he doesn't need to cock the gun, goes to the negligent use of a deadly weapon. However, everything else regarding him yelling at the crew or telling people to hurry up, none of that is relevant, and that is propensity evidence. So I think that you all can look at the videos, look at the any of those exhibits and agree which ones meet my ruling. And if you can't do that, then I'll have to help you out. Okay? So denied and granted in part. All right, state's motion in limine to exclude irrelevant evidence and witnesses. Let me know if you all need a bathroom break or anything. Otherwise, we're going to noon. Now you need a bathroom break.
This is state's motion limine 3, correct?
Yes, it is.
Okay. Your Honor, we filed this motion because we understand that the defense plans to call Robert Schilling. Mr. Schilling was a private investigator that was hired, who was hired by the prior prosecution team. When Ms. Morrissey took over the case, Ms. Morrissey terminated Mr. Schilling because he had done absolutely nothing on the case, essentially. So in response, Mr. Schilling sent an email to Ms. Morrissey and copied Mr. Bowles as well, and essentially criticized the law enforcement investigation and essentially said, I can't undo this disaster of whatever, I'm paraphrasing, of this investigation. So it was essentially a strong critique of the law enforcement investigation. I would respectfully submit that under United States versus McVeigh at 153 F 3rd 1166, page 1192, this type of evidence is inadmissible. Now, if there was, for example, evidence of what happened to the gun is going to be admitted, that's, the state does not dispute that or disagree with that. But just to bring in a witness to critique and criticize the law enforcement investigation is improper. And it's the type of evidence that McVeigh, the 10th Circuit Court of Appeals in McVeigh, noted would be improper. So we would ask that the court exclude Mr. Schilling from testifying, because the entire purpose is to bring him in to talk about how disappointed and disgruntled he was in terms of the investigation, but there's a motive there. He was terminated and he did nothing in the investigation. We're also asking the court exclude Sheriff Adan Mendoza from testifying. I believe the defense in one of its responses indicated that they don't plan to call Sheriff Mendoza, but in the event that they do, we'd ask that the court exclude him as irrelevant. There is nothing that Sheriff Mendoza did with regard to this substantively with regard to this investigation. He oversaw his deputies who were conducting the investigation, but he wasn't involved. And so to bring him in again, it's just to sit him up there to criticize the quality of the investigation. And we'd ask that his testimony be excluded as irrelevant. And I believe all he did was do some press conferences too. So I don't know if they're planning to inject that in front of the jury. And I would argue that that's irrelevant. And even if the court believes it's somehow relevant, it should be excluded under Rule 403 as more prejudicial than probative. The probative value is nil, essentially. There is another part of our motion, Your Honor. We're asking the court to exclude any argument or mention of the state's dismissal of the prior case against Mr. Baldwin. As the court knows, relevant, those are prosecutorial decisions that have no place before the jury. I would ask that the court exclude any argument or any presentation that the state did that. We also would ask the court to preclude the defense from making arguments that are aimed at garnering sympathy. For example, that Mr. Baldwin feels remorseful is irrelevant. It doesn't go to any issue and it invites jury nullification. So that type of argument should be precluded. I believe it conceded on the biographical information because, as we heard during many motion hearings, that Mr. Bash was the former U.S. Attorney for the Western District of Texas. That's irrelevant. Mr. Spiro was a former Assistant DA. That's irrelevant. Just like my time as an attorney for the U.S. Department of Justice is irrelevant as well. Those should be excluded. And the last part of this motion has to do with arguing inappropriate legal standards to the jury. Again, I believe in one of the motion hearings, Mr. Bash argued that, or it was argued actually to Judge Ellington before the grand jury, that the only way that the state could prove this case is if they proved that the defendant knew that there was a live round in this firearm. That's improper argument of the law. That's not what the law is. And so, and I guess this is an issue that the court will have to take up as we proceed during trial, but just wanted to alert the court because there's been some argument in the past that the defense is trying to rewrite the law in this case, and that's improper. Unless the court has any questions. Thank you.
Just to go through quickly each of the issues, because some of them are premature and I think we can push them off and probably won't raise issues. But to start with the testimony of Mr. Schilling, Mr. Schilling signed the probable cause affidavit in this case. He was an investigator in this case, just like Detective Hancock and the others. And there hasn't been a criminal defense case in the history of criminal defense cases where the defense lawyer didn't stand up and say the government's investigation was biased or improperly motivated or incompetent. That is Hornbook law. Why didn't you follow down this lead? Why didn't you put the gloves on? Why did you turn the lapel video off then? Why didn't you turn it on? These are all issues that are central to cross-examination in a case to challenge bias, improper motive, or incompetence. We've cited dozens of cases to you, Your Honor, cases where this wasn't admitted and it was reversible error. Schilling is part of the investigation. He's relevant to bias, motivation, and competence. He should not be excluded, number one. With respect to Sheriff Mendoza, we don't presently intend to call him. It's premature, I think, to exclude him. To the extent we want to call him, circumstances come up where it's appropriate. We'll raise that with you, Your Honor, in advance. But as of right now, we don't presently intend to. So I'd ask that you hold off on ruling because it's premature. With respect to biographical information, we don't intend to present biographical information, Your Honor. Don't think that's an issue. With respect to the evidence of what Mr. Baldwin's subjective knowledge was, we don't intend to argue that we are the givers of the law. Your Honor will, of course, instruct the jury as to what the law is. We do intend to argue that Mr. Baldwin didn't have subjective knowledge of a substantial risk to Ms. Hutchins' life because there wasn't a live bullet. In his mind, he didn't think there was a live bullet in the gun. You'll instruct the jury what they do with that, but that's certainly something we should be able to argue as to his state of mind. We won't tell the jury instructions. We won't tell them what to do. You will, of course, do that, Your Honor. And so you should deny the motion with respect to that issue. We don't intend to raise that either, Your Honor.
Thank you.
And again, if it comes up where there's a circumstance where it's appropriate, we don't foresee that at all, Your Honor, then we'll raise that with you, but we certainly don't intend to raise that.
And garnering sympathy.
Same thing, Your Honor. We don't intend to raise those issues.
Okay, thank you.
You're welcome.
All right. The court rules and reasons as follows. The court finds that Robert Schilling's testimony regarding the Santa Fe County Sheriff's Office investigation as to what he saw and learned during the investigation is relevant. The state will present evidence of its investigation and how Mr. Baldwin came to be charged as a defendant for involuntary manslaughter. Mr. Schilling's testimony addresses that part of the state's presentation of evidence at the trial, and the investigation is of consequence in determining the charges against Mr. Baldwin. The probative value of his testimony is not substantially outweighed by a danger of unfair prejudice. I will reserve on Sheriff Mendoza. Nole prosequi is stipulated to that it will be not introduced. The garnering sympathy is stipulated to that it will not be introduced. And I'm not going to, certainly you all can describe an opening statement what you think the facts are intended to show, and I think that you can describe what Mr. Baldwin's state of mind was without going into the elements. Okay, so it's granted and denied in part. All right, next up. This is state's motion limiting number 3. Defendant Alec Baldwin's motion in limine to preclude argument, testimony, and evidence relating to Baldwin's role as a producer.
It's the defense motion?
Yes.
Okay, sorry.
Did we? Yeah, I just did yours. Now it's theirs.
Thank you, Your Honor. Your Honor, the state intends to introduce evidence of Mr. Baldwin's role as a producer, even though Mr. Baldwin's role as a producer happened leading up to October 21st. As I just said a few minutes ago, Ms. Johnson told you nothing that happened before October 2021 in those civil cases is at issue here. The whole of the negligence, October 6 to October 21, that's the civil cases. That's not why we're here today. But the producer evidence is everything leading up to October 2021, October 6th through the 21st. They're trying to hold Mr. Baldwin responsible for what he did as an actor on the 21st because they claim he was reckless as a producer leading up to that time. That's a theory of vicarious liability in the criminal law that is not recognized. It's also far more prejudicial than it is probative because the jury's going to hear about what a producer does. They're going to hear about the producer being the boss, the buck stops with him, etc. And the risk is that they think Mr. Baldwin's responsible for what he did on the 21st because he's the boss, he's the CEO, he's in charge. But that's not a theory of liability, Your Honor. On top of that, there's no evidence at all, you won't hear any, that he hired Hannah Gutierrez-Reed, that he set the schedule, that he set the budget, period, full stop. What else did you hear? The state said Mr. Baldwin's role as a producer shows that he was keenly aware of the safety standards. Two issues with that, Your Honor. The state has said repeatedly in this case that Mr. Baldwin didn't violate the safety standards under Safety Bulletin number 1. He violated New Mexico law. They said that, page 29 of their opposition to our motion to dismiss the grand jury indictment. The fact that Mr. Baldwin was a producer is entirely irrelevant, highly prejudicial. It should be excluded.
Your Honor, as the court is aware, relevance does not exist in a vacuum. So the evidence that the defendant was a producer is relevant to demonstrate to the jury that as a producer, he is aware of his safety obligations, the safety duties, and there will be evidence of the bulletin number 1, which sets out movie set safety rules and how Mr. Baldwin indeed violated those. I think what Ms. Morrissey indicated in her response is that he did violate New Mexico law. But to demonstrate that the defendant's conduct was reckless on set, the state is also going to introduce evidence that he violated these set safety rules that are in place for actors and producers to follow. The arguments of defense, they go to the weight and not to the admissibility. They can cross-examine the witnesses because many state witnesses are going to testify that the defendant was the boss on set. And Your Honor, with regard to what this is relevant to, it's relevant to his recklessness because we have to establish, again, it's not just in a vacuum, that the defendant's conduct on this set was reckless, and therefore on October 21st, he should have been aware that his conduct of pointing a firearm at another human being, cocking that hammer and pulling that trigger is reckless conduct. And so I think that both sides quoted the producer agreement. There are no limitations to this producer agreement. And it goes to the issue of the defendant's reckless state of mind. And Your Honor, I just wanted to briefly address something that I think was relevant to the.
Tell me what the safety bulletin says that the producer, you referring to bulletin number 1, what are you relying on?
Well, there are a number of requirements as it relates to firearms, that the actor and producers are responsible for the safety of others on set, for the safety of themselves and of others on set, that they are to treat a firearm as though it's always loaded, do not point a firearm at another person.
I thought that was for the actor.
That is also, it's for both, Your Honor. These are set safety rules.
But what about, so you're not even relying on that?
We are, Your Honor.
In your response, you said that you weren't talking about the SAE guidelines, you were talking about New Mexico law.
Well, Your Honor, I think that these are two different issues that are being conflated. So Mr. Baldwin is charged with involuntary manslaughter under New Mexico law. And how do we prove that? We prove that by demonstrating his conduct, not just on October 21st, but in the days leading up, that by violating these on-set movie set rules, that his conduct was reckless, because it's not recklessness in a vacuum from a.
You're talking about the gun, okay? So tell me what you think he did wrong as a producer.
So not just about the gun, Your Honor. So there are two, and that's what I wanted to address there. So there are two components here. So we have his conduct as it relates to the gun, but then his conduct as it relates to, for example, rushing the armorer to reload that gun. That goes to demonstrate his recklessness. There's no regard for the safety of other people. When you're rushing the armorer to reload this firearm, mistakes can happen. And so with regard to his producer role, there is evidence that will be presented that Mr. Baldwin, as a producer, should be aware of all of the safety regulations.
So I did have trouble wrapping my head around this, as you can tell, okay?
I understand.
So the jury's going to hear this and they're going to go, well, Mr. Baldwin was the actor that was rushing, but he was also being a producer at the same time.
It goes to, Your Honor, because it goes to the recklessness. So he is a producer, and his contract states he's also the leading actor. So he's got a dual role, and with both roles, he fails in maintaining the safety of other people. See, what the defense is trying to do is just basically pigeonhole Mr. Baldwin as just an actor who relies on everybody else, and he relied on this armorer to not give him a gun with a live bullet. But his role as a producer requires him, there are more duties imposed on him as a producer. And those duties include, and there's expert testimony that will be presented, that his duties as a producer, well, I understand, Your Honor, but if the court allows the expert testimony, the state will present evidence that the defendant had not just his role as an actor, but as a producer, it's heightened in the sense that he is supposed to be aware of the regulations, of the safety, and that's the most important thing.
I'm just having trouble with this. Okay, I don't understand how you're going to say as a producer, he shouldn't have, as an actor and a producer, he shouldn't have he shouldn't have said, quick, move.
Well, but so as an actor, of course, he shouldn't have done that, but also as a producer, Your Honor, he is the boss. And as the boss, he is responsible for the safety of other people. So it goes to his state of mind, his willfulness, that he essentially, as the boss, failed the people who worked around him. And it gives him the power to control the safety. So as the producer, he has the power to control safety on set. And there was a tremendous lack of safety on this set. And so as the boss, he's emboldened to do whatever he wants to do. So this goes to the willfulness that the state has to prove.
Producer to do whatever he wants to do.
Because you're going to hear testimony from witnesses, if the court allows this, who will say he was the boss, he was calling the shots, he would rush people because without regard.
Maybe that's his personality as an actor.
Well, but that's irrelevant, Your Honor. With regard to his role as a producer, he has responsibilities, and he has a responsibility to maintain the safety of the set. Whereas an actor, perhaps those may be lessened, but as a producer, those are heightened. And so it's relevant to demonstrate his willfulness, the willfulness of his conduct, that on October 21st, he once again disregarded the safety of Ms. Hutchins and Mr. Souza and pointed that gun directly at Ms. Hutchins. And so that is why this is relevant. We can't look at this in a vacuum. And in fact, the court in State versus Duncan noted that relevance does not exist in a vacuum. Instead, it's the logical relationship between evidence and a proposition and issue that the party seeks to prove. We have to prove willfulness. We have to prove recklessness. So in order to do that, the fact that he was a producer and the boss is absolutely relevant.
Let me ask you something. So in the involuntary manslaughter, with respect to the first negligent use of a deadly weapon, okay, that's not the producer, that's the actor.
That is the actor, but he's also charged in the alternative.
The alternative, that he failed to check the gun.
It's more than that.
Well, that is what was given to the grand jury, that he failed to check the gun and pointed a loaded gun at at a person. That's what it was in the grand jury. So you want the producer you want to introduce that he was the producer and what he was required to do to be able to prove that alternative theory that he was supposed to check the gun.
Well, and that he wasn't supposed to point it at another human being and to pull the trigger. And so, and as a producer.
How does his role as producer, as a producer, he wasn't supposed to do that?
Well, his role as a producer goes to what he is required to know when it comes to safety of others. He has a responsibility to ensure the safety of other people. So it goes to the issue of his willfulness, that on October 21st, when he points that gun at Ms. Hutchins, he should know that as a producer, he's responsible for her safety, because that is one of the things that producers are responsible for, safety on set. And so the fact that there was a lack of safety on this set, Mr. Baldwin should have known that by his action of what he did moments leading up to the shooting of Ms. Hutchins, essentially show a willful disregard for her safety and recklessness. So it's not a theory of prosecution, it is evidence that goes to prove an element of the offense. And we would respectfully ask that the court allow the introduction of the fact that he was a producer, and that as a producer, he has obligations to ensure the safety of others.
And who's going to be your expert witness on that?
May I have a moment, Your Honor, to confirm? So we have two witnesses, Mr. Carpenter, who testified before the grand jury. In fact, he testified about the producer role. And then Kent Jorgensen, who is one of the individuals involved in drafting and updating the safety bulletins for onset safety.
You know that Brian Carpenter was not an expert admitted as a producer in Hannah Gutierrez. He was a firearm expert, and he has not been admitted as an expert because there was no judge to get him to be an expert at the grand jury. So he has not, at this point, been admitted as an expert as a producer.
Right, and we would tender him. Obviously, the court will have to do its gatekeeping duty and role. Mr. Jorgensen, however, and in fact, I think there's a motion pending about Mr. Jorgensen, but Mr. Jorgensen is also an expert on this. He's familiar with what the safety guidelines require of producers and of actors. And so these are germane issues that the state is required to prove, and we'd ask that the court allow the state to introduce this evidence.
Thank you.
Your Honor, I hardly know where to begin, because I honestly don't understand the theory or the facts that they intend to articulate to demonstrate that on October 21st, Alec Baldwin, the actor, committed involuntary manslaughter. They said, well, the safety bulletins explain that. Two things. Number one, they already said in their response that the safety bulletins weren't violated, New Mexico law was. Number two, look at those safety bulletins carefully. I'm sure Your Honor's read them many times. They say nothing about the producer not pointing the gun. They say the exclusive responsibility of gun safety is on the prop master, the armorer, the first assistant director. Doesn't say anything about a producer. There are a number of actors doing the same exact thing that was required by the safety guidelines. Those are SAG guidelines for actors, armorers, the first assistant director, and the prop master. They say, well, maybe it's because Mr. Baldwin was rushing before October 21st, and there, as a producer, I'm not sure what that distinction is, producer, actor, and therefore on the 21st he was. But you just excluded the evidence of him rushing because that's propensity evidence. That's inappropriate. The fact that we're so confused about what the theory actually is goes directly to the prejudice that will far outweigh the probative nature of this testimony. And we'll get into Mr. Jorgensen and Mr. Carpenter later, unless Your Honor wants to hear about why they're not qualified to testify as experts on producers. I'm sure we can push that on. But the reality is this will confuse the jury. This will be highly prejudicial. They want to show that he's the boss, and therefore on October 21st, as an actor, he committed involuntary manslaughter. That is highly prejudicial, inappropriate evidence, should be excluded.
All right, so what I think is more appropriate is I'm going to revisit this, make my ruling, no more argument on it. But I think that we should do the Mr. Those car, well, you didn't raise Mr. Carpenter except duplicative testimony. And
No, that's just the cumulative expert test motion, Your Honor, that's correct. We raised Jorgensen.
right,
If you want to do Jorgensen now, I'm
Right.
happy to come back up and talk about Jorgensen.
all right, let's do Jorgensen.
The state intends to offer Mr. Jorgensen on two issues. One is the role of a producer in managing the safety of the set. And the second is the safety bulletins that govern actors on movie sets. Mr. Jorgensen should be excluded. First things first, on the evidence of producer, his opinions on producer. Mr. Jorgensen has never been a producer in his life. He was a camera grip back 25, 30 years ago, never been a producer. We asked him, what is the basis for your testimony as to what producers do, know, what their obligations are on a movie set? He said, well, it's because I get to sit at the kids' table, these are his words, and listen to the adults talking. Your Honor, this is not the kids' table. This is the adults' table. Mr. Jorgensen has absolutely no expertise, and sitting at the kids' table doesn't allow him to sit over there and give testimony about what it is a producer is required to do on a movie set in a criminal trial on involuntary manslaughter, number one. With respect to the safety standards, Mr. Jorgensen didn't draft the safety standards. He's not a gun expert. He was a camera grip, sets up camera angles and scaffolding, etc. He is not a gun expert. He's not an armor. He's never been a prop master. He's never been a first assistant director with the safety obligations. His role, as he described it, is administrative. They want to draft safety guidelines. Mr. Jorgensen says, I'm going to go find gun experts. I'm going to delegate the drafting of safety bulletins to gun experts. They're going to draft it. Not Jorgensen, the gun experts are. And then the gun experts are going to send it back, and Jorgensen wordsmiths and edits. But it's the gun experts who determine gun safety standards on movie sets, not Mr. Jorgensen. He has no basis to offer an expert opinion about gun safety standards, what the standards mean, how they're supposed to apply, because he didn't draft them. He's not the expert. He doesn't know anything about them other than how they got drafted. But how they got drafted is not an issue in this case. His evidence, his opinions should be excluded.
Your Honor, Mr. Jorgensen teaches producers about their responsibilities with regard to set safety. He's going to take the witness stand. He can outline his experience, the position that he holds that allows him, that puts him in the position where he teaches producers about set safety. So I want to be clear. I am not calling Mr. Jorgensen so that he can come and just generally talk about this is what a producer does. I am calling Mr. Jorgensen to come in and talk about the producer's responsibility with regard to set safety. And Mr. Jorgensen is acutely familiar with this because he actually teaches producers what their responsibilities are and how they can have a safe set and avoid getting sued for killing someone. So we've got that as the first issue. Mr. Jorgensen is indeed one of the people who drafts the safety bulletins. I'm not sure where the confusion came in. Mr. Jorgensen is the chairman of the, it's on the tip of my tongue, the industry-wide labor relations. It's on my computer, my apologies. So in that role, what Mr. Jorgensen does is, here's how it works. Representatives from all of the different film unions come together. So we've got somebody from the Directors Guild and somebody from the Producers Guild and somebody from IATSE, and that's who Mr. Jorgensen is. They all get together and they agree and draft these safety bulletins. Mr. Jorgensen is one of those people who sits at the table, who drafts these safety bulletins. So his testimony is entirely relevant, one, because he actually drafts the rules that Mr. Baldwin is required to follow, whether we're talking about him as a producer or an actor or anything. And number two, Mr. Jorgensen sits with people from the Producers Guild of America to sit and discuss these safety bulletins and whose responsibility is what, in addition to teaching producers how to do this. So I think that his testimony is absolutely relevant with regard to, these are the safety bulletins. He lays a foundation for the safety bulletins. These are how the safety bulletins are created. This is a safety bulletin. This safety bulletin says, don't point a gun at anyone. Keep your finger off the trigger. Assume that anything that you point the gun at will be destroyed. Those are the safety bulletins that Mr. Jorgensen participates in developing. So his testimony is wholly relevant. Now, whether or not the court decides that Mr. Jorgensen's testimony with regard to a producer's responsibility as it goes to set safety is something that I think the court has indicated that you may want to reserve ruling on until you see and experience how the trial is unfolding. But there's no question that Mr. Jorgensen gets to come in and testify about the safety bulletins that he himself participates in drafting. Thank you.
Just a few points, Your Honor. The fact that Mr. Jorgensen is allowed to teach at some university about how people shouldn't get sued in civil cases, it doesn't make him an expert in this court. He's never been a producer. He's not an expert in being a producer. The kids' table doesn't allow him to sit at the adults' table, period, full stop. He also is not a gun expert. Didn't draft it. They're going to have Mr. Carpenter come and testify about safety standards with respect to using the weapon, pointing it, not pointing it. Now they want a cumulative expert, Mr. Jorgensen, who doesn't actually develop the guidelines. He's not the gun expert. He admitted that. He doesn't develop the standards. He said, I hire gun experts to draft those standards. They're going to have two experts, one of whom clearly not qualified on gun safety, Mr. Jorgensen, testify, and then put Carpenter in too. This is a afternoon, a day of testimony of cross. We already have a short schedule, Your Honor. You should limit this testimony. He's not qualified to give opinions on these issues.
Thank you. The court makes the following ruling. The court will accept Mr. Kent Jorgensen to be able to testify before the jury as to what the SAG guidelines say, but he has no qualifications to opine on what a producer does. He doesn't know how a producer implements those guidelines. So he can say these are the guidelines, but he needs to be a producer to say, this, as a producer, this is how I thought, this is how I meet these requirements. The other thing noteworthy about Mr. Jorgensen is that based upon his pretrial interview, which is what would have been the time to let the state know, or I mean, the defendant know what he was going to testify about, he was all over the place. And basically, he was like, well, I relied on Ross. I didn't talk to anybody. So yes, he will have hypotheticals about, and he may maybe sit over there in the gallery while he's and listen so that he can opine. But I think that interview indicated on top of it that my finding that he's not qualified to know what a producer does. So he can testify about the SAG guidelines, but he cannot opine on whether what Mr. Baldwin did as a producer was good or bad. All right, I'm going to revisit the producer. I'm going to make the following finding. I'm having real difficulty with the state's position that they want to show that as a producer, he didn't follow guidelines, and therefore, as an actor, Mr. Baldwin did all these things wrong, resulting in the death of Halyna Hutchins, because as a producer, he allowed this all to happen. I think that when you look at the relevancy, I think that one of the reasons why I think I'm having a hard time wrapping my hand around it, to be able to say, Mr. Baldwin, because he was a producer and he was the boss, although there are more than one producer, and he couldn't do anything without, looking at those contracts, he couldn't do a thing without running it by, including hiring somebody, without running it by whatever that entity is in the contract. But I do not believe that it has any tendency to make more probable than it would be without the fact that Mr. Baldwin individually as an actor committed involuntary manslaughter through negligent use of a deadly weapon and the alternative theory. The probative value is not substantially outweighed by unfair prejudice and certainly confusion of issues to the jury. So I'm denying evidence of his status as a producer. All right, shall we continue? All right, so we're going to the states now. That was Mr. Baldwin's motion. We have Jorgensen, we finished. All right. Defendant state's motion eliminating number 6 to preclude accusations of prosecutorial misconduct.
Your Honor, unfortunately in this case, or this case has been fraught with numerous accusations of prosecutorial misconduct. And they were raised in the context of motions to dismiss for constitutional violations. They were raised in the context of motions to dismiss the grand jury indictment. The court has ruled on those. Those allegations were perhaps relevant to those legal motions, but they're not relevant to what the jury is required to find. So I would respectfully submit, Your Honor, that the court preclude the defense from making arguments to the jury about prosecutorial misconduct and that the state did X, Y, or Z and it was unethical or improper, because that, number one, is irrelevant. Number two, it would be more prejudicial than probative. It also invites jury nullification. And that would be the main issue I would submit to the court, that the defense would be introducing this. And I noted on page 4 of the motion the allegations, for example, that obviously the jury's going to hear about the accidental discharge test that resulted in the damage to 2 internal components of that firearm. But to argue to the jury that that resulted in a constitutional violation to the defendant's rights is improper. The court has ruled on that motion. There have been numerous allegations of discovery violations and disclosures, and that they were designed to prevent the defendant from receiving a fair trial. Again, those are legal issues that the court is going to be deciding and has decided and have no place before the jury. That the prosecution conspired with law enforcement to intentionally damage this firearm, again, that went to the Trombetta motion that the court has already ruled on. There's another issue that there was a meeting you heard about in the motion hearing that Mr. Haig, Lucian Haig, had a virtual meeting with Mr. Ziegler from the FBI where counsel were present. And during that meeting, he asked Mr. Ziegler how he conducted the accidental discharge test. Now, while that is a proper area of inquiry for cross-examination, any implication that that was improper or unethical should be precluded, because under Rule 703, experts can confer with other experts in forming their final opinion. And there's nothing wrong with that. And so I had to bring this motion to the court, Your Honor, because I am concerned that there will be, throughout this trial, numerous allegations that the state has engaged in misconduct and trying to deprive the defendant of his right to a fair trial, and those have no place before the jury, and we'd ask that the court preclude that.
Let me just be clear about what we intend to do and what we don't intend to do. This is not going to be a trial about the ethics of the prosecutors. It's not going to be a trial about they should have dismissed the case a long time ago. They did, they took it back. Well, none of that's coming into this trial. No intention. What we intend to do is exactly what I discussed we were going to do with Schilling, for example. We're allowed to demonstrate that bias, improper motive, incompetence of the government investigation. We're allowed to attack the credibility of witnesses as it relates to the government investigation. For example, Your Honor already ruled that with respect to that meeting between Mr. Ziegler and Mr. Haig, that gets to be disclosed to the jury. In fact, the prosecutors are required to disclose it to the jury, you ruled. And so all of that goes back to the black letter law that we started with on that prior motion in limine. We're allowed to demonstrate the bias, the incompetence, the improper motivations. We're allowed to attack credibility. We're allowed to attack the fact that the FBI destroyed this gun, et cetera, et cetera, et cetera. All of those issues are fair game Hornbook law. We intend to introduce that. The state shouldn't be allowed to preclude it. I have nothing further, Your Honor. It's black letter law.
Thank you. Any reply?
Just briefly, Your Honor, I think we may be in agreement. What the reason for this motion was essentially to preclude the defense from essentially making personal attacks and allegations of prosecutorial misconduct. We agree, and we will present evidence about the Ziegler-Haig virtual meeting, about the gun. But we just ask, given the contentious nature of this case so far, that we focus on the evidence and not on allegations, personal allegations and attacks during this trial.
All right, thank you. The court rules and reasons. The court agrees that the prosecutor's misconduct as alleged by the defendant in his pretrial motions may not be brought out at trial. The misconduct is not relevant evidence, and even if it were, its probative value is substantially outweighed by the danger of unfair prejudice and confusing issues. However, to the extent that the defense may elicit evidence about the Santa Fe County's investigation, the FBI testing, the Haig's 3 reports, and his meeting with Ziegler, this evidence is relevant as it makes a fact more or less probable, and the fact is of consequence in the action. And weighing it, the probative value of the evidence is substantially outweighed by danger of unfair prejudice, etc. All right. Thank you. Now we're going to, let me just back up and do these two that. State's motion in limine number 4. Let me just make sure I haven't missed one. Okay. State's motion in limine number 4, which is no reference to the potential punishment in the case.
There's no issue.
All right. So that's agreed, stipulated. State's motion limiting number 5 to prohibit the defense from arguing to the jury examples of the definition of reasonable doubt.
No present intention to do so. I know that we'll discuss reasonable doubt, but those random hypotheticals, I don't think the court should preclude the defense from arguing anything that they choose to when you decide the law as long as it's relevant. But we have no present intention.
You're not going to give them an example of reasonable doubt. Okay.
Yeah, I have no present intention to do that.
Okay. And that doesn't come up, and that doesn't come up in voir dire either. Okay. All right, where are we? We've got defendant's motion in limine number 4 to preclude improper expert testimony from lay witnesses.
Thank you, Your Honor. The state wants to admit evidence from the camera grip, for example, about how dummies are made, safety standards for armors on set, safety standards for producers, etc., the camera grip. It wants to have the medic testify about the standards for armorers on set. This is improper opinion testimony that can only be given by an expert, not by a lay witness. The state cites the State versus Vargas case, Your Honor. They say it's a two-part test. Part number one is, can the lay witness testify about it based on personal observation? Part number two, can the lay witness rationally connect their personal observation to the opinion testimony? They say they can, because the medic has been on movie sets, it's personal observation. What the state overlooks is that before Vargas states that two-part test, it actually addresses a third one. That's the third prong of Rule 701, which says a lay witness cannot give testimony if it's within scientific, technical, or specialized knowledge. So Vargas says, testifying about movie standards, safety standards, armor standards, how dummies are made, the things that the camera grip and the medic, they want them to testify about, are within the specialized knowledge of someone on a movie set. As Vargas put it, it has to be only within the common experience and knowledge of a lay person. Now, how do we know that that testimony is not within the common experience and knowledge of a lay person? Because the state says so in its other motions. And I brought my notes up here so I can get the language exactly right. In one of its in limine motions, with respect to cumulative expert testimony, that's motion in limine number 8, here's what the state says. Many people, like many jurors, are not at all familiar with safety protocols on movie sets. And many of the state's experts are being called to educate the jury with regard to safe practices in movie sets. On the Jorgensen motion that we just went over, Your Honor, let me read from that one too. Safety bulletins and protocols on the use and handling of firearms on a movie set, as well as movie production requirements to ensure a safe working environment, are not within the average layperson's knowledge. They try to admit Mr. Carpenter's testimony on that too. They say this is specialized knowledge, expert testimony. They try to get experts in on it, but then they try to say it's just lay opinion testimony that the medic can offer, the camera grip can offer. They cannot have it both ways, Your Honor. And in fact, Vargas reversed a conviction when the court allowed that evidence. That was a police detective who was allowed to testify about his experience with a stun gun, how it was used, how it was made, etc. And the court allowed that at the trial level. The defendant said that's lay opinion testimony. That doesn't satisfy that third prong. It has to be tested under Rule 702. The appellate court said, you're right, reverse conviction. That was an expert testifying because the average and common experience is not that of a detective. And so it had to go through the gateway of 702. The state has not offered, has not disclosed Ms. Schaefer, Mr. Looper, or any of the other witnesses on this set as expert witnesses. They never made that expert disclosure. And to the extent they did, we would have obviously filed an in limine motion to exclude them as experts. They weren't offered as one, so we filed it this way, as experts, because the medic doesn't have the expertise to testify about armor standards, or the camera grip doesn't have the expertise to testify about movie production requirements. We just went through that with Jorgensen. And so this is lay opinion testimony that violates Rule 701, that has not been offered under 702 or met the guidelines of 702, and therefore any witness that they want to testify about any issue outside of what they observed on Rust, what they saw in other movie sets, what armors do on other movie sets, what actors do on other movie sets, is improper opinion testimony that should be excluded when it's offered by these lay witnesses. Thank you, Your Honor.
If I were the defense, I'd want this testimony excluded also. And let me tell you why it's relevant. Mr. Baldwin, part of his defense, and he's made these statements repeatedly, is I had no reason to think that Hannah Gutierrez wasn't a good armorer. I had no reason to think there was a problem here. This is what he says. He called Jason Bowles' office himself and said, I never had a problem with your client. I never had a reason to think that she wasn't a stellar professional. Well, Judge, you're actually in a unique position because you sat through the Gutierrez trial and you saw and heard the other people, the other crew members who worked on that set come in and say, we knew immediately this lady wasn't following the proper safety protocols. How do we know that? Because Ross Audiego has worked on 60 to 100 films and TV shows. Same thing with Lane Looper. Same thing with Sherilyn Schaefer. She's the set medic. She's paying attention to what's going on with regard to safety. These are not people who are being called as experts to come in and talk about set safety. These are people who are going to come in and say, we had safety concerns on this movie set because we knew from our experience, and by the way, this gentleman was the most experienced person on set, Mr. Baldwin. So if these other folks who had slightly less experience than him had concerns about whether or not Ms. Gutierrez was doing her job properly, this is the way that the state gets to combat the defense of there was absolutely nothing wrong with her. She was an amazing, stellar professional. This court knows that is absolutely untrue. So it is perfectly appropriate for lay witnesses to come in and say, I've been working on movie sets for the last 15 years or 20 years, or in Mr. Baldwin's case, 40 years. And I know exactly how these safety protocols work. And here's what makes it a little bit unique on a movie set is that the safety protocols that take place between the armorer and the actor and the first assistant director is this thing that happens out in the open, where the armorer says to all of the crew members, all of these people who are going to come in and testify, hey, does anybody want to see the rounds? Does anybody want to come and see me load the gun? Because you're the people who are standing potentially in the way. So all of these crew members actually get to participate in the safety check, even though he's a dolly grip, as though there's something wrong with being a dolly grip, even though someone is a first assistant cameraman or a boom operator, they actually get to participate in that safety check because it is their lives that are at risk. So each and every one of these people should absolutely be able to come in and say, I noticed that Hannah Gutierrez wasn't doing her job because Mr. Baldwin has told everyone Hannah Gutierrez was a stellar professional. We're not asking them for a bunch of technical knowledge. Absolutely, I will tell the court, I am not asking any of these witnesses to come in and talk about the difference between dummy rounds and blank rounds. Absolutely not. These witnesses are coming in to talk about, in part, their safety concerns as it related to Mr. Baldwin's conduct and the conduct of Hannah Gutierrez, and we can't really separate those two out because Mr. Baldwin's defense is she was really good. I would also point the court to, this is Farner versus, I don't know if I'm going to pronounce this correctly, Pakar. This is a federal case, 562 Fed 2nd 518. The admission of the lay witness's opinion that the Pakar suspension system was improperly designed due to its failure to incorporate the safety change was affirmed by the Court of Appeals. Much like the federal courts have allowed lay opinion testimony based on the witness's particular knowledge gained from their employment experiences, keeping in mind this is their workplace, so too should this court. There's a case right on point. Thank you.
Few issues, Your Honor. I'll talk about the cases first, and we'll go back to what Ms. Morrissey said she's going to try to use these witnesses for, and that's expert testimony. The Farner case, it's a design defect case. Farner was driving a truck. The truck suspension failed. There's an accident. Someone died. His widow, he did, and the person in the passenger seat. His widow sued the company that built the truck. She got a person who had driven, his name was Curtis, driven the same exact truck before. Not the same one in the accident, but the same exact make, model, etc. And he said, I drove that same truck. And you fix that design defect by wrapping these chains around the suspension. It was a design defect case where the question was, is that design defect fixable? This was an expert testimony. This was fact testimony. The same with the other cases, the Kate cites, the Valencia case, the Munoz case. Those are cases where the people worked at the company that was at issue in the fraud. And they were asked about that very company. When you worked there at the company, what'd you experience? What'd you see? That's relevant to the fraud. They didn't come in and say, I worked at some totally different company. In my experience at that different company, I'm going to apply it here. That's not at all what happened in that case. This case is Vargas, based on the experience that these witnesses had in other movies. Miss Morrissey told you they want to say, I've been involved in 40 movies before, and applying my experience there to this one, these are the safety problems I had. Even though there's that's expert testimony, because it falls right under that third prong. And number two, it is testimony that they are not qualified to give. There's nothing wrong with being a camera grip, Your Honor. There's something wrong with being a camera grip and testifying about the safety bulletins for armors. That's exactly what 701 and 702 say. And Vargas says it's reversible to allow it to happen. I have nothing further, Your Honor. Thank you.
All right, the court makes the following ruling. A lay witness can testify if rationally based on perception, helpful to clarifying an understanding of the witness's testimony or determining a fact and issue, and is not based on scientific, technical, or other specialized knowledge. Particularized knowledge is acceptable here, although I don't find it here on what they intend to do. Lay witness testimony of what they observed on set, providing that it's relevant, as compared to what they saw on other sets, makes a fact more probable than it would be without this evidence, and the fact is of consequence in determining the action. That is criminal negligence. It's they are not going to testify about the safety bulletins. They can only testify about what they observed on set, in this set, and what they observed on other sets, provided that they have a sufficient history to do so. However, again, we're going to have to decide relevance. Okay.
Understood.
All right. Court wants to take a bathroom break. All right, let's be back here at 1:15. Okay. All right, thank you. We're in recess.
Your Honor, if I may briefly,
Yes.
just at the end of the last motion, you noted in passing before we broke that issues with respect to lay opinion testimony would raise relevance concerns or relevance issues. And I just wanted to get some guidance on the court from that because we anticipate, for example, the medic, as I said, camera grip. We also anticipate people testifying that a few of the other actors on set did their own safety checks, even though those actors said they didn't think it to be their duty. And so
The last part of what you just said.
sure, let me approach, Your Honor, so you can I'll use the lectern so you can hear me better.
Me?
Is that better, Your Honor?
Yes.
Thank you. And so at the end of the last motion, you noted that issues with respect to lay opinion testimony would raise questions of relevance. And it'd be helpful to get Your Honor's guidance on that because we anticipate the medic testifying, the camera grip testifying about issues that, for example, were not reported to Mr. Baldwin, so don't go to his state of mind, or certain witnesses testifying about what a few of the other actors did on the set with respect to checking their guns when those actors themselves said, but it's not an actor's duty. And so we want to make sure that those issues are not introduced, for example, in an opening statement when ultimately it will be proven, in our view, to be irrelevant to Mr. Baldwin's state of mind, what another actor may or may not have done under the safety guidelines, or what the medic thought about the set but kept in her head and didn't report to anybody. Obviously, that wouldn't relate to Mr. Baldwin's state of mind without the reporting, or at least there's a question about prejudice outweighing the probative value of that when it goes to state of mind. And so it'd be helpful to get Your Honor's guidance on that with respect to these issues before opening, at least. We can submit more papers if you'd like, or
No, I don't want that.
I assume not, Your Honor, but that's why I'm raising it here orally versus submitting something to you.
Okay, all right, thank you. Does the state wish to reply?
Just briefly, Your Honor. So part of the defense here is this was Hannah Gutierrez's job. This is Hannah Gutierrez's fault. The truth is, Hannah Gutierrez wasn't doing her job properly, and everybody seemed to notice it except for the defendant. So it's true. We do intend to have witnesses say, I had concerns about the way that firearm safety was being conducted on set. In terms of whether or not it's relevant that other actors perform their own safety checks, I think probably just depends on how the evidence develops. I think my very first meeting with Mr. Nickus, one of the things that he explained to me is that there's a scene in the movie where the actor Travis Fimmel holds his gun to the back of the neck of the child actor. He's got his finger on the trigger and he's got the gun cocked. And Mr. Nickus said, Travis Fimmel would never have done that unless he felt safe with these firearms, unless he thought that these firearms were completely safe. Well, cut to reality now. The truth of the matter is that Travis Fimmel was one of the guys who every single time Hannah Gutierrez handed him a gun, took the gun and dry fired it into the ground more than 6 times to ensure that he tested every single chamber in the gun. So certainly if part of the defense becomes these other people pointed guns at each other and it wasn't a big deal, then obviously it becomes highly relevant that these other actors felt free to do it, because whether it was their obligation under the safety bulletins or not, they understood that that was a smart thing to do, especially when you've got this armorer who doesn't seem to know what she's doing.
All right, thank you. Oh, go ahead,
Just-
reply.
just-
Yeah.
Just some clarity, Your Honor, because I think it'd be helpful both so we can get the court's guidance and so we can understand what kind of case they're putting on if they give an offer of proof of these issues. Because, for example, if the medic comes in and says, I had safety concerns about on set, that's an opinion about the set that wasn't communicated. It's not to say she can't say, I saw Ms. Gutierrez running around. I saw her doing this. She was moving quickly. Those are facts. We're not trying to get out facts unless they turn out to be more prejudicial than probative, unconnected to state of mind. But her opinion about the safety of the set, that should not be included. That's irrelevant.
She doesn't get to do opinion. I already ruled on.
Exactly, Your Honor. And so what we just heard from Ms. Morrissey is, well, maybe it's relevant that an actor checked the gun on set in a different way for Mr. Baldwin, or he checked the gun at all. Maybe it's not. And so to actually get guidance from Your Honor, so we know what this case looks like when we're going into opening statement, having an offer of proof on these issues, I think will make sure that we don't end up having irrelevant testimony included, that we don't end up in the middle of opening talking about something that the state is or is not going to do with respect to these important evidentiary issues.
All right, so to the extent looking, I don't think I can't remember the people that testified in Hannah Gutierrez, but one was somebody that walked off the job, okay? And I think he has a pending.
Lane Looper, Your Honor, yes.
He did not testify during Gutierrez, Mr. Nichols.
Lane Looper walked off the job,
Well,
but he didn't testify.
somebody that was like the head camera guy walked out and looking at Ms. Morrissey because we were in the case. But so if he were to testify that I left the job because of safety concerns, that cannot just, it has to be related to what you're trying to prove. So it would have to be related to Hannah Gutierrez. I'm not sure where I see, that's off the top of my head that it would have to be related to Hannah Gutierrez and them observing that this armor was doing a sloppy job, and when they observed other armors, just pretty much what they testified to before. But if they're going to say things like nothing that would speak to him as a producer cannot come in.
Understood.
So if you're going to say, look, this person was sloppily handling the weapon and it doesn't relate to Hannah Gutierrez, then that's producer. That's not actor. Am I being clear on that?
I'm a little confused.
Well, I'm trying. I don't know. I don't remember the scene that you used, but let me just say this. So you're saying, that this actor had to check because he didn't trust Hannah Gutierrez. Okay, that's Hannah Gutierrez. Okay, but let's say the shooting, Sarah Zachary. Okay, when she shot, there were two, and Sarah Zachary shot on the ground or something like that. You would have to tie that to Hannah Gutierrez because that's producer issue.
So let me see if I can help out a little bit in terms of narrowing this down. I do not intend to put witnesses on the witness stand and have them say, generally, I felt unsafe on this movie set. I intend to have witnesses say, these are the things that I saw with regard to the handling of firearms that caused me to feel concerned. And in terms of an offer of proof, all Mr. Nickus has to do is just go read the transcripts from the Gutierrez trial that he's been shoving down my throat for the last 5 months, because that's what I'm intending to have the witnesses testify to. This is what I saw, and this made me feel uncomfortable, and it goes directly to the defendant's defense of not my job, she was great. I had no reason to doubt.
Yes, but it has to be related that Hannah Gutierrez's
Agreed.
job as an armorer. You can't just say, I felt unsafe because people were screwing around with guns. Because that might not be related to Hannah Gutierrez.
I agree with you. It has to be related to Hannah Gutierrez, or it has to be related to Mr. Baldwin's handling of firearms, which is directly relevant. I agree with you absolutely.
And one clarification there, Your Honor. October 8th, 9th, for example, Mr. Baldwin's not there. If someone testifies on the 8th, I saw Hannah do X and Y and Z, and I felt very unsafe based on what she did, they not only have to connect it to Hannah respectfully, but they also have to connect that to Mr. Baldwin. Because if Mr. Baldwin didn't see it, then this comes back to the imputed producer theory. He must have known safety issues on the set on the 8th, but they haven't demonstrated that, and they have to demonstrate that to have any relevance to his state of mind.
Well, I'd have to hear what it was.
Of course, Your Honor, but that's an example.
Oh.
If a witness comes in and says on the 8th, when Mr. Baldwin was not there, I saw Hannah Reed do something quickly or act unsafe,
that relates to Hannah, but it's not relevant to Mr. Baldwin's state of mind or his knowledge of Hannah. If they say on the 20th, I saw Hannah acting carelessly, here's what she did, she moved real quickly, Mr. Baldwin was there, he saw that, then that's fair game. That's my point.
Well, what you're saying is that the state can only introduce evidence that Mr. Baldwin was aware of, and I'm not sure that's correct.
If they're going to show that there was a safety issue on set with respect to Hannah Gutierrez on October 8th that Mr. Baldwin did not see or know about?
I don't know.
Okay.
Because the other way you could do this is that he was, with respect to, for example, David Halls, and how, you know, he said, well, he periodically checked the gun. And I'm not sure whether there was some kind of, I don't know how to put this, some understanding about how she was doing things that could be cumulative. I don't know. I would have to figure that out when it's offered. And I'm sorry.
No, the context is going to matter here, Your Honor. I just wanted to flag this issue because seeing the transcript in the Gutierrez trial, we did see the state try to introduce some of this, and we want to make sure it's connected to Mr. Baldwin.
We do not want a trial within a trial.
Precisely.
That's for sure.
Yes, Your Honor.
But we also want the state to be able to address that, you know, their theory that he should have checked the gun.
Understood, Your Honor.
Okay.
Thank you.
I hope that was helpful.
It was.
Okay.
And it'll come up and we'll ask
Yes,
for more
absolutely.
guidance when it comes up more precisely.
Okay.
I think I probably stand here, Your Honor, right? We've got the next in the
Yes, we do.
on
Okay.
inconsistent statements. Is that right?
No. Oh, yes, no. We already did the lay witnesses. This is motion in 95, previous contradict the state's. Let me use my list.
I think that's right, Your Honor.
Okay, we've done their 6, got to their 6. And
And there's 7, I believe. 7.
no,
Or 5 and 6, I'm sorry. So
okay,
we're back
that's
to
all right.
5.
Let's see. So we're on 5. Okay. Defendant Alec Baldwin's motion limited to preclude argument and testimony that contradict the state's previous factual assertions. Go ahead.
Thank you, Your Honor. So I'll make this brief. In the Gutierrez trial, the state made a handful of important statements that relate to what Mr. Baldwin did or did not have an obligation to do, or the cause of the underlying harm. For example, said Hannah Gutierrez Reed is the autonomous decision maker. Or if Hannah Gutierrez Reed had checked the gun again, it wouldn't have made a difference. Or the training or not of Mr. Baldwin with respect to the gun is not why Ms. Hutchins died. It's because of Hannah Gutierrez Reed, and so forth and so on. We put them in the brief, Your Honor. Those statements contradict a number of different elements of how the state has argued this case in the past. And we expect that those will contradict how the state intends to present its case this time. 2 things. Number 1, the case law is clear that the obligation of the prosecutor is to pursue the truth and not convictions, if there's a difference between them. And so the case law recognizes that it violates due process for a prosecutor to present contradictory theories across 2 trials that relate to the same matter. Now, they're not bound by the precise theory or the precise factual, underlying theory, legal or otherwise. The cases they cite are cases like Fry, where there are 2 defendants, the government doesn't know who actually shot the gun and killed the victim. And so it puts on a trial saying this one did and then this one did, because the government doesn't know. Those aren't internally contradictory.
Can I interrupt for a second? Aren't you rehashing what has already been done?
We're not, Your Honor, because the case law is clear. We can use those statements as party admissions. For example, look at the Bradshaw case
Okay,
that the state.
just a minute. First of all, that's not in your brief.
It is, Your Honor.
No, just a minute. You're not going to be able to argue what Ms. Morrissey said as a statement of what the prosecutor said in that case. There's a case, I thought this might come up and I should have pulled that case, but Justice Chavez did it, and it's contrary to U.S. Court case or federal court because it doesn't allow that in.
You know, there are two different issues here. One is, does it violate due process to do it? And the other is, are we allowed to present the state's contradictory
Okay,
statements?
so I already
And
ruled
let
it
me-
didn't violate due process.
Right, and so on the second, and that's what the cases say. That's what Your Honor is referring to. In the case, in the Bradshaw case that the state cites in its brief, it says, look at Justice Thomas's concurrence. Justice Thomas said the Supreme Court has not ruled on, and he wouldn't support a due process violation.
Mhm.
But then you have to continue reading that concurrence that the state cites. Justice Thomas says, if the prosecutor makes inconsistent statements, that risks undermining his case because the defense counsel can present those contradictions to the fact finder, quote unquote, or close enough, to the Thomas concurrence. And in that concurrence, Justice Thomas says, involving two different defendants, agrees with Justice Souter, says the defendant in the second trial can present those contradictory statements that were made by the state in the first trial to the fact finder, and the fact finder can weigh those inconsistencies as it will. The state does not cite, and that's directly from the Thomas concurrence that the state cites. We're not saying due process. We do argue that. We want to preserve that. But we should be able to present. In fact, their own case says we're allowed to present those inconsistencies. On top of that, the state does not cite a single case, not one, that says we're not allowed to present those contradictions in this case. Not a single case. They say it'd be prejudicial. But their statements, clear as day, what they said.
Let me find this case because it went to this. But okay, I'm listening. All right.
And they say 403, but Your Honor, they don't cite a single case that actually allows them to say X in one trial and then show up in a related trial and say not X or contradicts X. And we're allowed to present that. That's their own Thomas concurrence. In the U.S. versus Small case, for example, that talks about 403 and prejudice, says extraordinary remedy. They don't cite a single case for it, and they're asking for an extraordinary remedy. And all we're asking for is that the statements that this own prosecution made in this court, as an officer of this court, as Justice Thomas says we're allowed to do, present them to the fact finder here. Thank you, Your Honor.
All right, thank you.
Your Honor, with respect to the introduction of what are they're calling inconsistent theories, the U.S. versus Ganado Negro case addressed that specifically. That some courts recognize that while due process may prevent the prosecution from presenting inherently factually contradictory theories in different trials, there are those circumstances where there are evidentiary disputes about responsibility for a crime, for example, among several defendants. And in the Ganado Negro case, the court specifically recognized where there are cases where there are multiple defendants, as long as the prosecution doesn't present false evidence or factually or facts that are inconsistent, they can present theories that are different. And that's essentially where what the Ganado Negro case held. With regard to the admission of Ms. Morrissey's statements, Your Honor, we would be creating a trial within a trial. We would respectfully ask, now, while the court is correct, federal case law has noted that statements by a prosecutor in previous trials may be admissible as admissions by a party opponent. The state, I would submit to this court, is different, and this court can exclude those statements. This would be essentially Ms. Morrissey having to defend her previous statements. We're going to be doing essentially a trial within a trial, and we'd ask that the court exclude any statements made by Ms. Morrissey. And if I may just have a moment, Your Honor, I think I can pull that case that the court was referencing. But under Ganado Negro, the state should not be bound to the exact same theory of prosecution that it followed in the Gutierrez trial. This is a different trial. The facts are slightly different as they relate to this defendant's culpability. Unless the court has any questions, Your Honor.
No, I want to find that. It's not, it can be dispositive on other issues, but I want to find that case. I should have just pulled it.
Your Honor, if I may.
Yes.
Two things. As a precaution, if Your Honor would like to reserve on the issue, we can take a look at the case. You can hear a few minutes of additional argument after we've read it. That might be prudent, respectfully. Number two, you heard Ms. Johnson say, it's going to be a trial within a trial. It's 4 statements. The state made them. You just heard her say that the case law allows us to introduce the contradiction. She didn't cite a single case saying otherwise. She said it allows that. They've admitted that. Due process aside, that's the Garnegro case that she cites. If they want to present an inconsistent theory, then obviously we reserve and preserve the due process issue. But if they want to raise an inconsistent theory, then by all means, Justice Thomas says they can do that in his view. But you're allowed to show that it's a contradiction from what they said before.
All right, thank you. Well, that doesn't mean the court has to, so we'll take a look at that. All right. You could find that, and it was Justice Chavez. All right. Okay, we're on. Steve. Okay, state's motion in limine 7 to prohibit use or testimony of OHSB summary of investigation.
We have attached as an exhibit the summary of investigation that it seems clear that the defense would like to have admitted as an exhibit. So I want to address 2 issues. One, should the summary of investigation be admitted as an exhibit? And 2, should the findings, which I would argue are legal conclusions, be allowed in as testimony? So we've got the summary of investigation is hearsay. The public records exception to hearsay it was never intended to permit something like the summary of investigation to be admitted as an exhibit because it contains legal conclusions. It's actually findings and conclusions. That's what they call it. It contains legal conclusions. It is based on a law enforcement investigation. That's all OSHA does. OSHA enforces the Occupational Health and Safety Act. And in addition to that, the summary of investigation, as you can see, has numerous instances of hearsay within hearsay. And while the defense responded and said Ms. Morrissey hasn't pointed any of those things out to the court, well, they're all highlighted in the attachment. So yes, it's true. I didn't cut and paste everything from the attachment into my motion in limine, understanding that we do have page limits that the court has been concerned with. I can pull up the exhibit and I can certainly go through all of the different quotes where OSHA investigators say they actually put people's statements in quotes during the investigation. So that's hearsay within hearsay. Those quotes don't come in. The findings and conclusions are legal conclusions. So those don't come in because we can't have the jury hearing that Mr. Montoya and Mr. Genoway came to these conclusions, because it's going to cause the jury to think that they now have to come to the same conclusion. The problem with the OSHA report generally is that, one, they didn't do a very complete investigation, and I outlined very specific instances of where their investigation fails. And in addition to that, every time I read the OSHA summary of investigation, I say to myself, what is the relevance of this? What does this have to do with the case against Mr. Baldwin? And I want to put kind of in perspective, admitting not only the report, but testimony about the report is like let's say we're having a DWI trial, and it's a jury trial, and the jury gets to hear about the MVD revocation hearing. That's kind of what this is, only the MVD revocation hearing would actually be arguably more relevant and possibly more admissible than the OSHA, because OSHA is not concerned largely with the conduct of individuals. As you can see, Judge, the OSHA report basically says Hannah Gutierrez didn't do anything wrong. Well, we know Hannah Gutierrez did something wrong. We did an entire trial about it, and a jury convicted her in 2 hours. So it has nothing to do with the charges against Mr. Baldwin. Now, having said that, can the state or the defense call these witnesses that were interviewed by OSHA, put them up on the witness stand? Mr. Halls was interviewed, Mr. Baldwin was interviewed, Ms. Gutierrez was interviewed, numerous witnesses were interviewed. Can we call them and put them up on the witness stand and then refresh or impeach them with the statements that they gave to OSHA? Absolutely, as long as the testimony that they're giving in the witness stand is relevant to the issues in this case. And I'll tell you, on its face, I don't disagree with the findings of OSHA. OSHA found that Rust Productions was responsible under the New Mexico Health and Safety Act for allowing this hazard to be happening on this workplace. I completely agree with them. That doesn't have anything to do with whether or not Mr. Baldwin is guilty of manslaughter. The other thing that I want to point out is the defense wants to do this thing where they don't want you to allow us to bring in anything about Mr. Baldwin being a producer. But what's critical about the OSHA report is the OSHA report says it was the fault of the bosses. It was the fault of the producers. So if the OSHA report gets to be discussed and we get to hear testimony from Mr. Genoway and Mr. Montoya about the fact that this death was the fault of the producers, then we absolutely at that point get to point out that he's one of them. And he was in a position where he got to do whatever he wanted because he was a producer. So if the court is going to prevent us from raising the issue of Mr. Baldwin being a producer, and I respect the court's ruling, absolutely, then the OSHA decisions can't be discussed because they go directly to the fact that he's a producer. And that will open up this issue that I've had with Mr. Montoya in the past, where Mr. Montoya came up with this kind of fake notion of Mr. Baldwin's a producer, but he's not really responsible for anything other than creative. And Mr. Montoya came to that conclusion because he never looked at the contract and he just talked to Mr. Baldwin. When you look at the contract, and I put the language in our response, or I'm sorry, in my motion, he's absolutely a full producer. There are no limitations on his role as a producer. The language in the producer contract says he is expected to fulfill all of the duties traditionally known by movie producers. It doesn't say there's any restriction at all. So we've got some difficulty here because if they want it in, then producer comes in. If it stays out, producer stays out. So I would ask the court to look at it in that way. If OSHA comes in, the fact that he's a producer becomes highly relevant at that point in time. Thank you.
Three quick points, Your Honor. Number one, we've cited cases saying it's admissible. 8038C says if it's a criminal case, there's a factual finding, and it's a legally authorized report, it comes in under the hearsay exception. We've cited cases on that. Number two, Jorgensen, their expert witness who's going to testify under Your Honor's ruling as to the safety.
He's not an expert witness.
Jorgensen?
No, he's going to just testify about the guidelines. He doesn't get to provide an opinion.
Your Honor, Jorgensen has no factual knowledge of the rest set. What he,
Jorgensen is the guy with the SAG guidelines, right?
that's right. He
So I ruled that he gets to testify about the SAG guidelines, but he doesn't get to provide an opinion about the safety.
correct, Your Honor. And one of the issues is that, and we may use it or we may not, but when he was asked at his pretrial interview, what did you do to prepare for giving your opinion? He said, well, I didn't talk to anybody, some hearsay. I read the OSHA report a lot because he's an OSHA guy. That's his background. And so to the extent we think it's necessary to raise that, then that would be the limited context. And so ultimately, because it's admissible and because it may relate to their witness, we may have to raise it. And so that's the context in which it could come up. Number three, just for clarity, the report didn't say the producers are responsible. It said Rest Productions LLC, that's one person's company, is the employer, and the employer, not Alec Baldwin, the employer is the one that is being fined under that report. And so there's a very big difference between saying Rust Productions is responsible for violating these OSHA rules and saying that Alec Baldwin is a producer and he had a contract with Rust Productions and therefore he's responsible. That's not all what the report said. So these are not linked in the way that Ms. Morrissey described. Nothing further.
No, Your Honor.
Okay. Court makes the following ruling. I already ruled that producer liability or whatever does not come in. So this OSHA report is specifically prepared by OSHA to go in and investigate whether the employer had any responsibility, and they were in fact fined. If that testimony comes in and by oral and including written, then you have opened the door to producer. And with respect to you saying that the only reason why we may bring it up is because Jorgensen may mention it. Jorgensen's not going to mention it because I already said only safety guidelines. Okay?
Thank you.
All right. Okay, so that's granted. I want to keep track of my omnibus order. All right. Defendant Alec Baldwin's motion in limine to preclude argument, evidence, and testimony regarding the victim.
Thank you, Your Honor. We addressed this briefly earlier when I withdrew our request to admit the medical records. It's axiomatic and not disputed that a victim's good character and all the wonderful things about them is not relevant to a criminal trial. They don't really dispute that. What they do is they try to sort of come up with ways to backdoor that evidence by giving other reasons. Like they say, well, we need to explain why Mr. Souza hired Ms. Hutchins. And so Mr. Souza needs to explain all the background about Ms. Hutchins in order to explain his hiring process, which is, of course, completely irrelevant in the first place and an obvious backdoor and not particularly intellectually honest. Then they say, well, the reason we have to explain where she was born and how she grew up is because there's one moment in this case in thousands of pages in which one witness mentions that she speaks Russian to another witness. So in order to understand that, you have to understand where she grew up in Ukraine and all of that, and her childhood and all of that, to understand that. And of course, that's also intellectually dishonest. And all you have to say, if you care about making sure this court is and this jury does not, decide this based on emotion and sympathy and the wrong reasons, is you have to say, did she speak Russian? Yes. Did you understand she understood Russian? Yes. You don't have to go into the 30 years of history here. So that's the way to deal with that. In terms of exhibits, it's also very, very simple. They talk about the lapels. I agree with them. The lapels at the scene are relevant. You don't show the positions of the bodies on the ground. It's not relevant. It's not in dispute. It's not a fact in dispute. It doesn't tend to prove anything. I agree with them. The autopsy is relevant, not the photos. The photos don't help anything. The person who's doing the autopsy is more than sufficient. And let me say something else. And this is why I wanted to quickly withdraw the application for the medical records, which is we don't dispute anything about any of this. This is not an issue in this case. You will not hear us cross-examining or questioning the fact that she passed away or the cause. In the other trial in which you presided off, there was at least some testimony, some indicia that they intended to proceed that way. And maybe that had something to do with why so much of that evidence came in. That is not an issue in this trial. It's just not. And so every single time that evidence comes in, it's wholly irrelevant because I've just told the court we're not making an issue of it, and it's extremely prejudicial. It is the most extreme possible weighing of the scales that one could ever have, because it is completely irrelevant. Because I'm saying, I agree, she passed away because of this. So, and their real reasons for doing this is obviously exposed.
Okay, so you're sort of combining everything. Why don't you go through each one that you identified?
Sure. The character of the deceased victims I just did. The moment of death and subsequent pain is obviously completely relevant. The emotion they say in here.
Did you just say completely relevant?
Irrelevant. They say that the reason that they're eliciting it is to bolster witness credibility. That is a per se improper reason. They say that they say evidence is relevant and it explains a witness's conduct and bolsters. They're using emotional sympathy, drama of something to bolster a witness's credibility. The fact that she suffered might be irrelevant or admissible in a wrongful death case. It's not in a homicide case. It's nothing to do with it. Nothing. And to the idea that they're going to use it so that the witness is upset on a witness stand and saying, and this is how she fell, and her face was pale, and this, and now everybody's upset, and trust me, I saw what I saw about something relevant, is exactly what a court can't allow. It's exactly what a court can't allow. And they did this the entire trial with, and I mentioned this before with where is she now? Is she in the medical vac? They ask all of these, why is even one time, the tone of her skin as she falls, why is that possibly relevant to this trial? And they do it with every single witness they did it with. So then you get to the lapel cameras and the autopsy photos. And so I was trying to track this precisely. Again, we agree that the lapels of the scene are relevant, right? You just don't need to show a body on the ground. It's just not necessary. And the autopsy photos are particularly problematic. They don't show, how are they relevant? We could stay here for days and no one could explain to me how the autopsy photos are relevant. They're not. If the court wants to voir dire the medical examiner and say, is it possible for you to explain this without presenting these graphic, vivid depictions of a tragically killed person? They're going to say, of course I can. Autopsy photos get ruled out all the time, especially in cases like this. This is not, a whodunit where it's like, okay, let's look at this, but I'm saying I didn't do it. This is a tragic accident where two people who are known to each other and no animosity towards each other, this occurred. And so it doesn't have anything to do with the case or anything relevant. And I'm telling the court that we're not making an issue of this. So if the court knows that, unlike in the Hannah Gutierrez retrial, that this is not in dispute, I really don't understand the basis to allow a single witness to do any of that, a single witness, let alone the cumulative every single witness, which is just being done to taint the jury
and to try to get the jury to do something on sympathy. Thank you.
Dave?
The state has no intention of presenting evidence related to Ms. Hutchins' childhood. So we can eliminate that right off the bat.
What do you plan on?
Well, we believe that there is limited testimony from Mr. Souza that's appropriate because jurors don't know how the film industry works. He should be able to take the witness stand and say, as the director, I got to pick my director of photography. Here's what the director of photography does. These are the reasons I picked this person. We're not going to have him talk about, she's an honest person. She's an amazing mother. She's an amazing wife. None of that's coming in. But he gets to tell, we get to put the story in context for the jury. And I think that we can do that without doing all of these things that the defense is claiming are so highly prejudicial. I have no problem limiting that testimony with regard to Ms. Hutchins, but certainly the jury gets to hear what she did, how she was hired, how does this come together? How do all of these people come together on this movie set? That's absolutely relevant. Now, with regard to the lapel videos, the defense says, we think the lapel videos are relevant, but we just don't want the jury to see the human part of it. And that's kind of hard for the state because we kind of have to prove that a human being was killed. That's part of what we have to do here. So the other thing that you have to understand is that the defense probably is going to take a similar tactic in this regard that we saw in Gutierrez. And they're going to question all of the law enforcement officers about, why didn't you do better? Why couldn't you have done this? And why couldn't you have done that? And the answer is, this was extremely chaotic. We've never shown up to a crime scene where there were 150 witnesses there. There were people mulling around everywhere. There were things that we had to do. Those lapel videos show how difficult and chaotic that scene was, and it goes directly to their defense. And listen, I mean, they act like these lapel videos are like a horror movie. You see Ms. Hutchins on the ground, you don't even see blood. You don't even see blood coming out of her. You see Mr. Souza's yelling because he got shot in the shoulder. That's not overly prejudicial. Absolutely not. There is tons of case law where, and the lapel video of them laying on the ground is very, very similar in terms of the analysis as the autopsy photos. Autopsy photos come in. They do. They come in every single case. I have never had a case where autopsy photos were excluded. And I even cite to a case in my response where the court actually says, basically, we've never heard of a case where there was a reason to exclude these. They just come in. Now, listen, I want this court to know that during Gutierrez and during this trial, there are autopsy photos in this case that are shocking to the conscience, that we could argue successfully are relevant. Because when you crack open somebody's body, you can see how the bullet traveled. And autopsy photos actually show that. We're not asking to get those in. We are doing exactly what we did in Gutierrez. We have just 2 to 4 very benign autopsy photos. We have been more than reasonable in terms of trying to turn down the volume on on emotional response with regard to these autopsy photos. I was actually stunned to see this motion after we exercised so much restraint during the Gutierrez trial. And those are the same pictures. We haven't upped the ante here. We're not trying to show anything other than, look, this is where the bullet entered. This is where the bullet came out. Those are relevant. Those are relevant to Dr. Gerald's testimony. Those come in. They come in every single trial. There's just a reality associated with the fact that someone died. I am more than surprised to hear Mr. Spiro come up here and say, we are not disputing the cause of death. The whole reason that we have probably 4 or 5 witnesses on our witness list is because the defendant put Dr. Bianca Alvarez on their witness list. They called her, talked to her on the phone without inviting us. And the whole point to doing that has to do with this farce defense of she didn't die of a gunshot wound. She died because she wasn't intubated properly. So I want to say right now, because we're short on time in this trial, if the defense is not intending to make any arguments that she died because of a faulty intubation, let me know, because I can shave a lot of witnesses off my witness list that way.
Thank you.
Thank you.
State did not address even slightly in either their motion papers, in the Halyna Gutierrez retrial, or in that response, anything about how ashen she is or how the moments happen after matter. They don't. They didn't address it in their papers. They didn't just address it now, right? So I just want to make sure that the court, as the court was well to point out to me, demark these issues. They have not addressed that. There is no dispute that that's not possibly relevant to talk about how the person was dying and what their skin looked like and their breathing. It's just not relevant. They then go into this, how Mr. Sousa selected her to understand the film industry working. I mean, Your Honor, it's like they don't ask a single other witness, right? Well, how did you get hired? And why did you get hired, right? I mean, so I'm sure that the court sees through this. If somebody were to say to me, this is the one question and answer, and there was an offer to proof, I'm sure we could work this out. But how can I possibly trust this process if we don't hear that exactly because of what I've seen? And then I'll just deal with the autopsy photos. Again, we're stipulating to identity and that she's deceased, and that we're not saying that some other causal factor killed her. So this makes the balancing test very, very easy. That doesn't happen in every homicide case, right? And also, I wasn't, I don't say these things in front of juries, but I actually prosecuted homicide cases. No, and often there is a discussion over, they don't always come in. And often there is this thing where sometimes prosecutors want to put them in to gin up the jury, and judges make calls all the time that it's just not necessary. We don't need to remember her that way. We don't need to do that in this case. I don't need to do that in this case. And this court can very well, like the court said to me when this hearing opened, take order of the court and has the discretion to say, no, pictures of this tragic dead body is not necessary here. I'm telling the court again, I'll say it now, I think the second time, which is we are not making an issue out of the cause of death, period. They want to take these people off the witness list, they can. But if that's what we're doing, and I've withdrawn our seeking the medical records, then I've left the court with very simple, in my judgment, balancing test. And I'd ask the court to really think about when this verdict comes down, having faith that this was a fair trial and the verdict was based on the right reasons. You can't have, it's hours of testimony, hours in the Halyna Gutierrez trial about it. And it's different here because the gun was in his hand. The gun was in his hand. So to allow hours and hours of testimony, when we have, the state has 5 days to present this case and we need the opportunity to rigorously cross-examine, it doesn't make any sense. I don't think it's fair, and I don't think the court should allow it. Thank you.
All right, the court makes the following ruling. All right, with respect to the character of deceased of the deceased, certainly if Mr. Baldwin was going to get up, you'd want to go, how did you come about getting this this job, so to speak? And I think it's just an introductory way to to tell the story. Now, I do remember Mr. Souza going into, we met, I liked her, we had things in common, et cetera, et cetera. I think all that needs to be said is that she was one of some choices. He felt that she was a good fit and that she was the director of photography. That's it. Okay. Now, with respect to the moment of death and subsequent pain, I think that does go to the death. That's one of the elements, and the death and the injury, the death, and I do think that that makes a fact more probative, and that is the death, and that I don't think that is its probative value substantially outweighed by unfair prejudice. Having said that, I'm trying to recall everything that occurred regarding that, and I do think that the video is appropriate. Now, I think there were some people that got up, and this may be what both of you have referred to, where they talked about being upset. They talked about, how upsetting it was and things like that. We don't need that. We just need the lapels videos as to what happened with respect to her being shot and Mr. Souza being shot as well. So that's the lapel camera depicting the crime scene. Am I misunderstanding anything else on that?
From the defense's perspective, a lot of this also goes to 403 and cumulative list, right? So
Could you just answer my question? Okay?
yeah, well, I think the
I don't
answer
want
is
you to
yes.
argue again. You already had your chance.
I think the answer is yes, Your Honor. I'm not, if I understood the court's ruling, I think the answer is that yes, if the lapel videos are the way that they're going to show where the bodies were or the
This is
man.
when Lieutenant Benavides is in there and he says, "Everybody clear out." Is that the video?
And primarily also Officer LaFleur, who's the first officer on scene, that video
Right,
also
where people are rendering aid.
right.
All right, so that comes in. Autopsy photos, again, you can stipulate, that's fine, but they're allowed to tell their story, and they're allowed to demonstrate the death. I do remember there was an autopsy photo that was pretty much agreed it was prejudicial, or maybe it was somewhere else, where her shirt, I think. Which part of the autopsy photos? I don't know. But the autopsy photos in my mind are the body.
So just to iron it out right now, we've got pretty much the same photos of the body that we showed during Gutierrez, nothing overly dramatic. And there is a photo of the bloody clothing, and part of the reason that's relevant is because her cause of death was exsanguination, so she bled to death. So the photos of that amount of blood go directly to her cause of death.
I will allow that. All right. You can revisit that, defense, but I do anticipate you may bring up some information about the tubing.
Just to say that and I know the court has one more argument, but the court's looking at me for guidance on this. That we're not going to do that. We're not maybe going to do that. We're not going to do that. So when we say that we're not going to do that, the court can count on that, and that makes those.
Well, you didn't say that. That's my point.
Oh, I thought that's what I was going to address.
You could ask the doctor. You said you didn't care about the UNM records, but that you didn't say you weren't going to ask the doctor.
If I wasn't clear, I'll make it more clear, which is we are not going to ask the doctor about that. So if we're not going to seek to introduce medical records, and we're not asking the doctor about that, there isn't a basis of relevancy anymore. There just isn't. And so I'm asking the court that they now have several ways the court has just allowed for them to present that this was a death, which we concede. So, right?
All right, that's fine, but they still get to do it. I'm saying no to you.
Right.
All right, so let's not do the shirt if they're not. Well, no, I'm going to allow the shirt. You said that she bled to death. There's nothing wrong with that. All right.
And I'm gonna start calling off witnesses then to testify that she was correctly intubated. Are we clear that the defense is not going to raise that issue?
We are not raising that
issue as to the cause of death, and we maintain our objections to the exhibits, and we understand the court's ruling.
So just to be clear, the video, and all I'm remembering is the video, okay? So if there's something else that comes in about in the church, then we need to revisit this because I am making a ruling about the video. I don't remember if there were any photos. I don't think there were photos, but I remember the video, okay? They get to put on what the church looked like. Secondly, and also that gives an understanding of where Mr. Souza was for various reasons. Then with respect to the autopsy photos, I'm not sure whether that shirt is more prejudicial than probative. You can get out that she bled to death in different ways. I'm not sure that that's necessary. I'll revisit that.
Okay, and what I can do, Judge, if it helps, I can email copies of the photos to you so you can look at them. I mean, Dr. Gerald isn't scheduled, the photos come in through Dr. Gerald, and she's not scheduled to testify until the end of our case.
I don't want to revisit the autopsy body photos.
I hear you. I can send you, and I apologize. I understand why I just got my wires crossed. Some of the photos of the bloody clothes were taken by OMI. So what I can do is I can email to you, and of course CC the defense, those photos of bloody clothing so that you can look at them and you can make a determination long before the witness ever takes the witness stand, what's appropriate and what isn't. Understanding autopsy is something different. You've already ruled on that.
All right, thank you for that.
Your Honor, if we may go back to the state's motion, defendant's motion on limiting number 5, I found the case that the court was referencing.
Okay, what is it?
It's State versus Montoya. It's 2016 Westlaw 3639984. It is a Justice Chavez opinion, and the issue begins in at paragraph 42 and 44, where the court did not allow the defense to introduce the prosecution's opening statements or statements during opening in a previous trial.
There's 2 State versus Montoyas.
Yes, Your Honor. This one is it's a Westlaw site.
Oh, I see. Okay.
It's 2016 36399. Oh, sorry, I just lost it. Let me go back. So it's 2016 Westlaw 3639984, and it's Justice Chavez opinion.
And Your Honor, we can take a look at that in the break as well and give you our views, if we may.
Mm-hmm.
Thank you.
Just wanted to see if it was the one I remember. Okay.
Sorry,
Is this opening statements?
that was the reference to opening statements.
That was the next one.
All right. State's motion in limine 8 to allow use of exhibits during opening statement.
Your Honor, we don't have I think there's a way to shortcut this, which is that as long as the defense can also put in exhibits and the court will, if there's any issue between the 2 sides, address those 1 or 2 issues. I'm hoping that there's not. We would not, as long as it's equal to both sides, we would not have an issue.
Are they going to be admitted?
Yes, Your Honor. In fact, I provided defense counsel this morning a copy of the exhibits. I have a copy for the court if you'd like to look at them. What I would request is that they provide us today with a copy of the exhibits that they intend to introduce in
All
case
right,
there are
but do
any
you
issues.
think there's going to be an issue on admission at trial?
No, Your Honor.
I don't believe there's of the exhibits that we're putting forth. We're putting forth basically the same set, a little bit more of a videotape or a little less, and the 911 call. That's it. So there's very few exhibits that we're using at opening, and I don't think any of them are an issue.
All right, well, I want you all to agree because I do not want us to stop in opening statement. Okay?
Yes, Your Honor.
So if you don't agree, let me know.
Yes, Your Honor.
All right, defendant Alec Baldwin's motion limited to preclude argument, testimony, and evidence related to the incident from the Crow.
Thank you, Your Honor. We move to exclude the state presenting evidence of what happened on the Crow as evidence of Mr. Baldwin's state of mind here. The state has said it will not present evidence of what happened on the Crow, but what the state did say is it intends to address and present the theory essentially from the Crow that blanks can kill. Mr. Baldwin knew that, and therefore he's responsible for having the criminal state of mind necessary to prove involuntary manslaughter here. There are 4 problems with that, Your Honor. The first is, let's go back to the indictment. The indictment says that Mr. Baldwin is being charged because it was foreseeable to him that if he didn't check the gun for live ammunition, it says nothing about blanks, not a single word, then his use of the gun by pointing it and pulling the trigger, they allege, could cause significant risk of harm to human life. That was the theory of the indictment. Live ammunition, nothing about blanks. A few witnesses mentioned here and there blanks in the context of an accidental discharge. They get loud, you have to put your goggles on, your earmuffs on, people get mad. There is no testimony in this case about that blanks kill in this particular situation. The case theory has always been, they've said it over and over and over in the papers they've submitted to you, Mr. Baldwin didn't check for live ammunition. He pointed the gun, he pulled it, and then Miss Hutchins died. So they're trying to vary significantly from the theory of the indictment. Problem number 2, causation. Mr. Baldwin not checking for blanks and then pointing the gun did not kill Miss Hutchins. She was not killed by a blank. She was killed by a live round. And all the testimony shows that blanks are very different from live bullets. If Mr. Baldwin checked for a blank, there would have been no blanks there. And so they have a major causation issue as a matter of law in presenting this brand new theory that was not in the indictment. Number 3, there's a foreseeability problem as a matter of law with their intention to present the blanks theory. The Henley case, as Your Honor knows, we've briefed it for you, says the requisite criminal state of mind needs to match or converge, is what the case says, with the criminal act. And what the state's doing here is they're playing apples and oranges. They're saying Mr. Baldwin had the reckless criminal state of mind because he knew that blanks can kill. That was foreseeable to him. He didn't check for blanks, and then Miss Hutchins died. But the act that he's been charged with is not, he didn't check for blanks and Miss Hutchins died as a result of a blank. It's that she died as a result of a live bullet. So they're mixing apples and oranges here. They're trying to take what they say is a foreseeable risk and match it with an act that didn't cause the death. So that violates the very clear requirement of Henley that the state of mind and the act converge. That's not what they're saying here. And then last but not least, there is 0 evidence in this case, 0, that Miss Hutchins would have died, or it was expected that she would have died, if you look at the foreseeability cases, if there were a blank in that gun. The foreseeability cases say it's not what can conceivably occur. Blanks can kill. It's not what can conceivably occur. It's what's expected, what's objectively and reasonably expected. There's 0 evidence in this case. They don't have an expert. They don't have a fact witness that can testify. Certainly a fact witness wouldn't be allowed to testify about this, that if Mr. Baldwin had a blank in that gun, in that moment, it would have killed Miss Hutchins. 0. There was no obstruction in the barrel. They keep on saying obstruction in the barrel. There was no obstruction in the barrel. He was feet away, 2 feet, 3 feet, 4 feet away from Miss Hutchins. It was pointed at her armpit. There's nothing in that gun that could have pierced her body. There is 0 evidence. If you look back at The Crow, if you look back at the history of motion pictures, there are 2 incidents where a blank was involved in a death on a movie set. In 1984, an actor put the gun directly against his head, and the pressure pulled the trigger, and the pressure from that directly against his head killed him. In The Crow, so very different from what happened here, miles and miles and years apart. Number 2, in The Crow, what happened was the crew was making dummies out of live bullets. And when the dummy was put in to the gun, it still had residual gunpowder. And the primer got hit. It knocked the bullet tip off, it discharged. And then there was a blank loaded behind that live bullet tip from a live bullet that people on the set were making improperly. Still no criminal prosecution there. Said it was civil negligence, not criminal, but that's not the point. The point is, if you look at what happened in both of those cases in the history of motion pictures, they are entirely distinct facts. The state cannot come in at the last minute and say, blanks can kill. Mr. Baldwin knew that, and therefore he had the requisite state of mind, and they match it up with an act that killed Miss Hutchins. Zero evidence that that would have happened here, and therefore they cannot present it as a theory when there's no causation for it, there's no foreseeability for it, there's no evidence for it, and it's not in the indictment.
All right, thank you.
Thank you, Your Honor.
I'm looking at the indictment that was filed in this case. I don't see anything that says live round. I have it right in front of me. So I'm not exactly sure what Mr. Nickus means when he says, if you look at the indictment, he was indicted for that. I'm looking at the indictment. It doesn't say anything about that. So I want to try on occasion to agree with the defense. I want to try to come together. The issue of, do we want to have witnesses testify about what happened on the set of The Crow? No, of course not. I intend to present absolutely no testimony with regard to, I expect no witness to say The Crow. But here's why this is relevant. The entire defense is Mr. Baldwin had no reason to believe that there was a live round on set. Well,
Is it on set or in the gun?
I think they've argued both. They've argued that he had no reason to believe that there was a live round on set, that he had no reason to believe that there was a live round in the gun. So, and here's what they're going to argue. They're going to say this gun is completely inert. He should be able to treat it like a toy because everything is completely safe. Yeah, but the problem is that these safety bulletins and these rules that the defendant failed to follow were created because real guns on movie sets are dangerous. That's the whole reason they were created. And one of the ways that we know that they're dangerous is because if you combine a blank with a barrel obstruction, you can kill someone. It's not what Mr. Nickus said, that there's no reason to think that it would have killed anyone. It would have killed her if there was a blank and a barrel obstruction. I agree with him that that's not what happened in this case. But the point is, real guns are dangerous. The SAG safety bulletin from the Screen Actors Guild says blanks can kill, underlined, bold, exclamation marks. Mr. Baldwin's state of mind is what's critical in this case, and Mr. Baldwin understood real guns on movie sets. Even best case scenario for him, we imagine that there's no chance that there could be a live round on set. He still knows they're dangerous, and he understands that the rules exist because they're dangerous. The rules that say, don't point it at anyone, keep your finger off the trigger. Those are all the things that were designed because real guns on movie sets, even if there's not a live round, can kill people. Mr. Nickus can stand up here and say blanks don't kill people. They certainly do kill people. And the Screen Actors Guild Safety Bulletin says blanks can kill. So the problem is that the defense theory is this was a completely inert gun. And the only thing that made it a problem was the fact that there was a live round in it. And that's simply not true. And it goes to Mr. Baldwin's state of mind. It goes to exactly what the state has to prove, which is that he knew or should have known of the risk when he pointed the gun at someone, cocked it, and pulled the trigger, live round or not. He understood that risk. That's what we have to prove, and that's what we're going to prove.
Well, it was in the grand jury hearing that the indictment doesn't say it, but
Sure.
You did to get the true bill. You talked about live ammunition in a gun.
Sure, absolutely. And that's certainly a part of this case. And I don't want to pretend that it isn't. Because the other thing that we know, and we put this in some of our responses, is that when Mr. Baldwin was being interviewed by Corporal Hancock, he actually said to Corporal Hancock, I'm wondering if Hannah commingled live rounds with her dummy rounds. He knew that there was a possibility that a live round could find its way on set. He didn't even know that Ms. Hutchins had died yet, and he told Corporal Hancock, I wonder if they were commingled. He knows that these guns are dangerous. And listen, the state isn't, I've had countless cases where the prosecutor has a slightly different theory at trial than they did in front of the grand jury. There's nothing improper about that. We're not amending, we're not trying to add charges at the last minute. I don't understand exactly what the issue is. If there's case law that says that I'm married to absolutely every single theory that was put in front of the grand jury, it's news to me, because I've had courts amend grand jury indictments in the middle of trial based on the evidence. And the evidence in this case is that this gentleman knew that you can't point a gun at someone and pull the trigger, because even if there's not a live round, it might kill somebody. He knew that. And I agree, we don't have to get into what happened on the Crow, but at the same time, the safety bulletins are made because of that. They exist because of that.
Thank you.
A few issues, Your Honor. In terms of the indictment, it was in the grand jury instructions on which the indictment was based, to be clear. There's nothing in the grand jury instructions, in the indictment, in this case, where the actual allegation of the charge is that Alec Baldwin didn't check for blanks, and therefore he's committed involuntary manslaughter. This, in terms of time, Your Honor, and sensitivity to cumulative witnesses and cases within cases, this is a case within a case. It's a hypothetical case about an act that didn't happen, that didn't cause the death at all, with, on top of that, significant questions about whether it's even possible when we know from the history of motion picture, it's never happened in this way. Who are they going to testify? Who are they going to have testify, the state, that Ms. Hutchins would have died if there were a blank in that gun? What expert witness is going to say that? They don't have a single expert witness. They don't have a single fact witness who's allowed to testify about that. They don't have any evidence that there was an obstruction in the gun. There's literally no evidence of this. And if they want to put on a theory that merges different state of mind with this hypothetical act that didn't cause a death, then we're going to have a very confusing trial with multiple different witnesses being asked, have you ever been on a movie set where a blank killed someone? Have you ever been on a movie set where a blank shot and pierced someone's body in a way that was really dangerous? Have you ever had someone on a movie set shoot a blank in a way that did anything other than cause a little rash or hurt someone's ears or make their eyes have stars in them? We're going to have a trial within a trial about a hypothetical that was not raised until the very last minute. It wasn't the basis for the charge in the first place. They have foreseeability issues, they have causation issues, they have evidentiary issues, and there are major notice issues. And in terms of cumulative testimony and wasting of time in cases within cases, that's what this theory is going to become. Thank you, Your Honor.
All right, thank you. All right, the court makes the following ruling weighing whether it has any tendency to make a fact more probable or less probable than it would be without it, and whether its probative value substantially is outweighed by unfair prejudice. I think it's difficult to deal with what I read in the grand jury transcripts about, the theory about the negligent use of a deadly weapon is just his manner of handling, that he shouldn't have caught the gun, et cetera, et cetera. And then with respect to the alternative, it is that he failed to check the gun. He failed to confirm that the gun, I remember the word confirm about live ammunition and, before he pointed it at someone. I think that I will not allow any testimony other than one sentence statement, probably by your expert, Ms. Morrissey, that says that blanks can also kill. But to consider that he failed somehow, that's just going to be up to the trier of fact. I think everybody knows guns can kill. It depends on what's in there, but I think that you can mention it. But that's it. We're not going to go through 5 different questions on tell me how and how serious this is, and you know, he's a gun owner and he's done all these westerns, or not westerns, but all this gun experience, and he should have known it. Just say that, and if you can tie that up, great.
Understood.
All right, let's take our lunch break. Okay. All right. What else are you going to surprise me with? Exhibits? What are you going to do? I mean, because maybe we can have an hour lunch.
I want a real exhibit list from the defense that doesn't list
You
every
don't-
piece of evidence.
They probably feel the same way.
Well, we were pretty specific.
I do think that given the court's guidance today, that there could be, I'm hoping that the opening exhibits all work out, and I'm hoping that this slowly streamlines the process.
The board here is 50 minutes max a piece.
You said 50?
50.
Okay.
50.
And
Oh, let me just be clear on board here, so as you're getting ready for it. Questions. I know I'm looking at you, but he's standing. Questions, not just keep standing. All right, no, okay, you can sit down. Okay, questions, not your theory, your hi, how are you, you know, questions, okay? And the issue is fair and impartial, okay? Not maybe this isn't the case for you. We're not shopping. It's fair and impartial, okay?
Yes, sir.
And questions.
I'm
emphasizing questions. You ask questions. You don't talk to them. Do you understand what I mean? I mean, I'll give you latitude, but I'll have to pull you in if you're not trying to get fair and impartial.
I'm just wondering, in terms of what sent us into individual voir dire during.
I'm not going to do individual voir dire.
Okay.
I think this is different.
And I'm just.
Well, I'll hear you out. Okay, I'm sorry to interrupt you.
No, and listen, it may not turn out to be an issue, but my only concern is if we start to have potential jurors who say, I don't think that I've seen in the press that he didn't know that the gun was loaded, and I don't think that he should be prosecuted. I think that there was a concern in Gutierrez that if we have all of these jurors just giving their opinions because they've seen things in the press, it kind of poisons the well.
Right.
So
Well,
that's my only concern.
first of all, my intent is, and I'm open to hearing from you all, but when that happens, I'm just going to call you up and agree that this person should be stricken for cause and he can leave. What do you think?
Sure.
Yeah, it would have to depend on the, how extreme it was, but I think we'll be able to
Right.
make eye contact, frankly, and figure out some of this. I'm hopeful. Yeah, I don't know how the court, I wasn't there at the first trial, and I don't know how the court is planning to design this. There is, of course, in both directions, a risk of pollution of the jury pool, right?
Right.
Yes,
Absolutely.
So I think that if anybody has, extreme views on anything, maybe that's a way to sort of say that you're going to hear questions, and if you think that you have a view that should not be spoken publicly,
Mhm,
and you
sure.
would like to speak to me
Right.
and the lawyer separately,
Right.
you can so indicate when
Right.
you raise your hand.
Right.
And
Well,
that-
that's part of my instruction.
Right.
Okay, that you can speak in private. And most people start saying, well, I want to speak in private. Or you say, do you feel like you should speak in private? And they'll say yes. I'm less inclined to do private voir dire because it just took so long. And the other thing is that, think about it. I think we're going to have 79 on the panel, and we will be able to know immediately. You're going to get five and 3. Is that right? Yes,
Yeah.
5 and 3, and for causes, and we'll know whether we need a second jury panel by then.
I just want to throw this out there. One of the things that may speed up the process, if we do have a juror and we think that they may have some potentially prejudicial things to say, rather than kicking everybody out of the room, maybe we can just invite that person up
Yes,
to
so
the
I've
bench.
done that. Yes, I've done that.
Okay.
I agree that makes sense.
Okay. Was anybody thinking private?
I just wasn't sure.
I think it's easier to do the subset of private when necessary and not invite it at the start. The judges that I try cases in front of always think that if you invite it too early, then it becomes a domino effect. I'm just repeating what other
No,
jurors have said.
I expect a lot of folks will want to speak in private about this, but I just, I think this is different, a little different from Hannah Gutierrez.
And will we be addressing the entire group or just?
Yes, 79.
You'll do the whole group in our questioning?
Yes, and then if you can't pick a jury out of 79 folks, which I find highly doubtful, then we'll call in the next panel, okay?
Thank you, Your Honor.
And does the next panel come in that same?
Staggered, yes, it's staggered. That's why when we're finished with the 79, I want to know if I have a jury. So, yes, I want to know how many, and we'll know probably by the 4 causes.
Understood.
Okay. All right, well, and so do you want an hour for lunch or do you,
So the only thing that I would say about the exhibits, and I mentioned this before, but perhaps we're getting even further, which is, I've just told them about one part of their case is not going to be necessary, and they disclosed when that witness would be testifying. If the state can even provide some shell, okay, right now we have still at 44 witnesses and 13 experts. Any guidance, I'm not holding them to the guidance. The court need not. I'm not going to ask the court to hold them to the guidance of the gist of the case. The gist of the case and their expected witness, we are going to be able to very, very quickly say, okay, then those lapels, that issue, it becomes irrelevant, and I'm going to be able to deliver to the state what they're going to ask the court for.
Okay, very good. So what we're going to do is we're going to take an hour lunch because we're almost finished with these. And then the court is going to instruct you all to meet and confer about what you all think about your cases and streamlining. Okay? All right.
Thank you.
All right, we're in recess. All right. Defendant Alec Baldwin's motion to eliminate to preclude inadmissible cumulative expert testimony. Go ahead.
Thank you, Your Honor. And if you'd like, I can also address the Montoya case that you said you'd like to revisit. If you'd like to do that first or later. Okay.
Thank you.
You're welcome, Your Honor. Your Honor, we've moved to exclude cumulative experts and witnesses that the state has intended to call and put on their witness list. 44 fact witnesses, 13 expert witnesses. We have an 8-day trial, 5 or 6 days for the state, many of them duplicative for medical experts, multiple gun experts, multiple experts on multiple issues. And we're in this impossible situation, Judge, where we're a day and a half away from the start of this trial, and we have no idea the order of witnesses they intend to call, which of the witnesses they intend to call. It's severely challenging our ability to present a fair defense, to present and prepare for the witnesses that they intend to call. This is the time and past the time for the state to say, this is the case they intend to put on, these are the witnesses they intend to call, and give us some transparency into how this trial is going to be conducted so that can be conducted in an orderly way with witnesses that we're prepared for and on notice of. Thank you, Your Honor.
I'm not quite sure how to respond to that. So Brian Carpenter is a necessary witness. Kent Jorgensen is a necessary witness. Paul Jordan, I'm going to decide whether or not I think I can cut him. I can't make that decision at this moment. The Haigs are necessary witnesses. Pietta's a necessary witness. Ziegler's a necessary witness. Let me tell you why. Even though Mr. Baldwin told OSHA investigators there wasn't anything wrong with this gun, it worked fine. The problem with it was a live round. The defense is centered around the gun was modified, the gun didn't function properly. I've got, how many video exhibits have I disclosed to the court? 40? The reason that you've got so many is because that's how I prove to you that the gun was working fine, is because they're filming him and the gun works fine. He cocks it, it stays cocked. He decocks it decocks the way it should. He fires it fires. So my witness list and my experts are designed to deal with their defense. And that's what I'm supposed to do. That's what I'm allowed to do. So if they don't want to hear from the Haigs and Ziegler and Mr. Pietta, who's coming all the way from Italy, then they can give up on the silly notion that the gun was modified and that it malfunctioned. But until they do that, there's nothing I can do. I did reach out to Mr. Spiro with a thought about whether or not we could stipulate to the testimony of Mr. Gillette. Mr. Spiro, understandably, was not able to give me a quick answer because it was something that he needed to discuss with his client. And because Mr. Gillette lives in Virginia and is the explosives expert for the FBI, I couldn't just sit on my hands. But hope springs eternal. If we can come to a stipulation with regard to Gillette's testimony, I can strike Gillette. We may not call Dr. Carrillo now that we've heard from them. Finally, let's talk about transparency. That they're not pursuing the she died because she wasn't properly intubated theory. So we're going to hold Dr. Carrillo in abeyance and assuming that this issue is never raised, as Mr. Spiro has indicated that it will not be, then she will not be called. But we certainly reserve the right to handle that however we see fit. It's entirely possible that we are not calling Shannon Prince. We will have to call Geraldine Conway because of the defendant's obvious public defense that he didn't pull the trigger. And I don't believe that we're calling Mr. Primo. So that's the transparency that you get from me now.
Just briefly, Your Honor. We've got Jorgensen testifying about set safety. We have Carpenter testifying about set safety. We have other people testifying about set safety. They want Mr. Jordan to come and testify about set safety in Montana. We'll deal with that separately. When you look at this witness list, 44 fact witnesses, 13 experts, four medical experts testifying. When you heard Mr. Spiro say we are not challenging the quality of the intubation or the cause of death, this is a witness list that is ballooned far beyond what's even remotely possible in a trial of this length. And so we're asking for, it's a good start of the transparency. Appreciate what Ms. Morrissey said, but we need a whole lot more of that in order to put on a fair and efficient trial and to be properly prepared for the witnesses that they intend to call, or else we're going to have witnesses testifying over and over and over again about the same exact subject matter, which is exactly what we're allowed to move to exclude on the basis that it's cumulative and it wastes time.
Okay.
Thank you.
All right, first of all, I have not looked at the witness lists, so I know the number because you all keep telling me the number, but I'm certainly not in a position to start telling the state which is a better witness for this testimony and which is a duplicative witness. This is their case, and they know how much time they have. You said you'd use 1 to 2 days what is it, 8 days? 8 days. And so the state knows what they need to do. With respect to the roles and responsibilities of producers, that's already out. Brian Carpenter and Ken Jorgensen are not going to, Ken Jorgensen's going to be talking about the safety, but he's not going to be getting into producers. And since producer is out, Mr. Carpenter's going to be left to do firearm safety. So I'm not noted, and I'm sure it's noted by the state. They're well aware of the time frame they asked, and I said no for more time. So denied. All right, next up is state's motion eliminate to prohibit double hearsay containing CAD reports.
I have the CAD report in front of me. The narrative statements that I believe are double hearsay that should not be admitted are on page 14. Everything else I think is perfectly appropriate as long as the proper foundation is laid for the hearsay exception. So my complaints are just the narrative in 14, and because it's just inadmissible hearsay, I don't see anything that's terribly prejudicial in those statements. But at the same time, they're hearsay, and they're hearsay within hearsay. So that's all I'm trying to get rid of is page 14. Thanks.
Your Honor, I'll be similarly brief. Part of what we were going to argue was that we couldn't really do a meaningful analysis since we didn't know what exactly the state was attempting to exclude. We now have that information. Based on the court's directive, we are going to be engaging in a meet and confer after this. I think that would be an appropriate time for us to review what the state has just indicated they believe is objectionable. We will determine whether or not we believe that there are exceptions, see if we can reach agreement. If not, then we can bring this before the court. This should be a very brief analysis based on the number of things they're saying they object to. And I think we can present it to the court before we get started, either tomorrow or the next day.
Thank you.
Yes, Your Honor.
What is on page 14?
So, Judge, when you've seen these CADs in trial before, what it is police officers call in and they say such and such, and then it gets typed down, or a witness calls in and then it gets typed down. So that's all it is. And one of the reasons that I want to exclude it is because some of the information is just incorrect, and I see that in CADs all the time. For example, they're talking about who's been shot. 1-10-41 shot in the chest and one male shot in the stomach. He wasn't shot in the stomach. I don't know how they got that idea. But those narrative comments are frequently incorrect, and they are in this case as they are in many cases. So that's it.
All right. Well, typically this information will come in under hearsay, so we'll see how that goes.
All right.
All right. So as long as it meets a hearsay exception, I'll let it in. You all can talk about it, okay?
All right.
Defendant Alec Baldwin's motion limited to preclude improper opinion. Oh, we already did that one. Okay. Jorgensen. Defendant Alec Baldwin's motion limited to preclude improper opinion and testimony from Paul Jordan.
I think we should go ahead and argue it because we haven't had a chance to think about it. Go ahead.
Thank you, Judge. We've moved to exclude the testimony of Paul Jordan. Paul Jordan was not on the set in New Mexico in October of 2021. He knows nothing about what happened on the set in October of 2021. He said he read about what happened there, a little bit on the internet, heard some hearsay from some witnesses, but has absolutely no knowledge whatsoever. And so what does the state want him to testify about? They want him to testify about what happened 2 years later in Montana. They want him to say Mr. Baldwin had difficulty getting on and off a horse and therefore apparently defies safety guidelines because a man with a hip replacement gets off a horse in such and such a way and therefore the crew's unsafe. They want to testify that Mr. Baldwin, he wants to testify that Mr. Baldwin had an attitude. We asked him anything else. He said, I don't think so. Mr. Baldwin had an attitude. Trying to introduce evidence from what happened in Montana, completely different circumstances, different people, different reasons for the movie, different facts, entirely distinct 2 years later, has absolutely no bearing on whether Mr. Baldwin should be convicted of involuntary manslaughter 2 years before. Thank you, Your Honor.
Having already indicated I may cut Mr. Jordan off of the witness list, I will indicate that that's not what we would call him for. None of what Mr. Nick has said really is why we would call Mr. Jordan. Mr. Jordan was the safety consultant on the continuation filming of Rust in Montana. The unions required that the continuation of the filming have safety consultants who had complete autonomy, who could not be overruled because of the obvious issue that took place in New Mexico. What Mr. Jordan indicated is that Mr. Baldwin insisted, and that was his word, that he, Mr. Baldwin, not have to follow the safety consultant's safety recommendations. Stunningly, 2 years later. And we've given the court the law that says that subsequent bad acts are admissible. This goes directly to this ongoing willful and wanton conduct. It is just additional information of willful and wanton conduct. Thank you.
You know, this is the same 404B other acts evidence that you excluded with respect to what happened before. Now they're trying to do it after. There were no live guns on the set in Montana. They were not real guns. There's no possibility of harm with what they were doing. We asked Mr. Jorgensen, what did Mr. Baldwin do? He didn't say he was unsafe with guns. He said getting on and off a horse, an attitude. Has no bearing on Mr. Baldwin's use of guns on the set in New Mexico. And the case that Ms. Morrissey's alluding to is the Rijo case that we talked about with the 404B evidence, where the individual lied about his commercial trucking license application before, and that was the predicate act for the crime, and then lied about it after, which showed that A, he committed the predicate act, and B, he was aware his physical condition didn't allow him to drive because it was dangerous. That's not even close to what they're using it for here. They're trying to show that Mr. Baldwin had an attitude and didn't comply with horse riding regulations or safety guidance, and therefore was reckless with a gun 2 years before. There's no connection. It's highly prejudicial. There's no basis for admitting that evidence here, Your Honor, and certainly not from someone like Mr. Jordan as an expert.
Thank you. The court makes following ruling. This falls under Rule 11404, prohibited character evidence. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion, the person acted in accordance with a character or trait. So it's not coming in. Thank you. All right. State's motion eliminate to prohibit hearsay statements allegedly made by the victim.
To try to cut to the chase here, I agree with the defense position that the statements that Ms. Hutchins is alleged to have made, and I indicated to the court that the vast majority of the witnesses do not support that she made these statements. Mr. Baldwin did not tell Corporal Hancock that she made these statements. In fact, he indicated to Corporal Hancock that it was a male who was telling him where to point the gun. Mr. Baldwin referred to that person as a he in the context of that interview. It would appear that Mr. Baldwin was referring to Mr. Souza. So it isn't until later that Mr. Baldwin begins to create this narrative that it was Ms. Hutchins who was telling him where to point the gun, and that's how she ended up getting shot. So if Mr. Baldwin takes the witness stand to testify, I believe that it comes in for the effect on the listener. I agree with them there. The other witnesses, the other 2 or 3, I disagree. I don't believe that it has an effect on them as the listener. So these statements are highly unreliable. They are so unreliable that Mr. Baldwin himself indicated that the person who was telling him where to point the gun was Mr. Souza. So I don't want these statements that have absolutely no indicia of trustworthiness to be admitted by the 2 or 3 witnesses who seem to say that she said something. And as I indicated in the motion, those witnesses can't even agree with each other about what she said and how that could have directed Mr. Baldwin's conduct. All of them agree that Ms. Hutchins did not say, point the gun at me. There is only one witness who says that Ms. Hutchins told Mr. Baldwin to cock the gun. The other 2 witnesses who support that she said anything at all agree that she did not tell him to cock the gun. So I just want to get this ironed out before we find ourselves in trial and we have all of these completely unreliable statements coming in from witnesses who don't agree. Thank you.
So, Your Honor, first I want to start with the fact that we seem to have skipped a step in the analysis with the state. The state has, kind of initially, at least in their motion, jumped to whether or not Ms. Hutchins' statements would have fallen under the hearsay exception 8033. But there's another analysis that has to happen first, and that is whether or not the utterances or the words that were spoken actually even meet the definition of hearsay, period. First, it has to meet the definition of hearsay before you have to get into the analysis of whether or not there's an exception that applies. Because if it doesn't meet the definition of hearsay, the analysis ends there. It's not hearsay, so we don't have to get to the exceptions. So what we do is we look at the words that were uttered, and then we see whether or not it falls under 11801. And 11801A defines a statement, which it must be, as a person's oral assertion, written assertion, or nonverbal conduct if the person intended it as an assertion. And so what's central to that is that the words that were uttered have to have been intended and have been an assertion. And the case law is clear about what that means, and we'll get to that in just a moment. The second paragraph, paragraph B, has to do with the fact that that the declarant is the person who made the statement. And then C is where we get again into what happens with the statement. And C says, hearsay means a statement that the declarant does not make while testifying at the current trial or hearing, so it's an out-of-court statement. And 2, that a party offers an evidence to prove the truth of the matter asserted in the statement. So again, central to all of the definitional pieces of 11801 is that the words that were uttered have to be intended as an assertion. And there is case law on that, which we have cited in our motion. And the case law very clearly indicates that non-assertive statements are not hearsay. And that means a statement that cannot be proven true or false. So an assertive statement would be, the car was blue, the light was green. That is something that can be either true or false. It's true if the car went through the light and the light was green. It is false if the car went through and it was actually red. Other words or utterances like commands or directives are not assertions and therefore not statements under the definition of hearsay. So for example, point the gun here, or let the gate down, or don't jump in the puddle. Don't jump in the puddle is a directive or a command, and it is not true or false. It's just a statement. It's a directive, rather. And so by definition, it is not hearsay. It does not fit the definition of hearsay, so you don't even have to go into whether or not there is an exception that would apply. It doesn't fit the definition, and the analysis ends there. And so in this case, what we're talking about is the statements by Ms. Hutchins, which would have been directives. Point it this way. Show me the action. Show me the action is not a statement that can be either true or false. It's a command to do something. And so therefore, under the case law, which we've cited to the court, it's clear that that is non-assertive utterances that therefore are not hearsay. So the analysis should end there. Because the state addressed these other issues, I will address them as well, although it's not necessary for the purpose of this analysis. So the state tries to say, state of mind, and I believe they just conceded to some degree that they said if Mr. Baldwin testifies, then his state of mind becomes relevant. The state misunderstands what the rule is with respect to the effect on the listener. There's no rule. Again, that's an instance where you say, okay, we're not offering it for the truth of the matter asserted, again, because it has to be an assertion, but rather for the effect that the utterances would have had on the listener. It doesn't say the effect on the declarant, it says the effect on the listener. And if Mr. Baldwin is being given directions by Ms. Hutchins, then it would explain why he did what he did, and that would be the effect on the listener. And we can look at the circumstances, the surrounding circumstances, to give us an indication that he did then rely on those statements. Now, lastly, the state also talks about that this would be potentially inadmissible because they're concerned that there's this disagreement between the witnesses as to whether or not she said anything or what she said or didn't say. The jurors, though, are the finders of fact, Your Honor. The jurors get to hear all of the testimony, and they get to make the determination about whether or not they think she said anything. If she did say something, what they think she said. That's literally their role. They are the finders of fact, and they get to make a determination as to credibility of the witnesses. And we actually have an instruction in New Mexico. There's an instruction, it's 14-5020. And that one says that, among other things, the witnesses can determine and consider the witness's ability to observe, the witness's truthfulness or untruthfulness, the witness's motivation or bias to testify a certain way, among other things. So the jurors are going to be instructed as to how to consider credibility and what weight to give the different witness testimony is going to be up to them. But I want to add that I think it's a little bit difficult for the state to argue that the admission of these statements is just unreliable, because we actually have in the statement of probable cause, which I have a copy here for the court's convenience, if I may approach. And if the court will turn to the second page under the statement of probable cause, I've highlighted a sentence there. which states, and again, this is the prosecution's statement of probable cause, which was signed under oath. And we have Baldwin was practicing drawing and pointing the weapon for the scene with guidance and instruction from Halyna Hutchins and Joel Souza. That's in their own statement of probable cause. And so I think it's a bit difficult for the state to argue that there's not enough indicia of reliability or relevance or import for this to go to the jury when it made it into their statement of probable cause. And so for those reasons, we would ask that the court deny the state's motion and allow that to commence. Thank you.
Cause number D101CR 2023-00039. That case is no longer pending. Because when I took this case over, I had to make a lot of changes. But one of the changes that I had to make was getting rid of the person who wrote this for his inability to fully understand the facts of the case. So here's the issue. I have a transcript of Mr. Baldwin's statement to Corporal Hancock in front of me. This is Mr. Baldwin's statement. I believe my recollection is she was there, turned a bit, like talking to him. He's saying Ms. Hutchins was talking to someone else, obviously not Mr. Baldwin, not the speaker. So I think she was hit in the right armpit, but this is all I know. And that is that I take the gun out in rehearsal where he wants it, very dramatic and very slow, trying to sneak up on them. I take the gun out, and as I take it out, it clears, the barrel clears, the whole turn and cock the gun over here. I turn and cock the gun goes off. That's just one of his numerous statements where he indicates that it was a male who was telling him where to point the gun. So part of the problem is that, sure, the defense can come up here and say, this isn't an assertion, this is a directive. Their own client didn't say that it happened. Never at any point in time during this interview does he say that it happened. And the vast majority of the witnesses who were in the room don't say that it happened. Now, is Mr. Baldwin allowed to forget a detail, obviously a very important detail, and then testify different when he's on the witness stand to what he said to Corporal Hancock? Absolutely. But he's got to take the witness stand to do that. That's my position with the court. Thank you.
All right, the court makes the following ruling. First of all, assertions can be, or directives can be assertions. So I certainly researched that. But what I'm ruling is that the statements are not being offered for the truth of the matter asserted. That the statements were said in defendant's presence and had effect upon the listener demonstrated by his actions. I have done a lot of research on the case law to make this ruling as to whether the defendant has to testify to be able to get that exception in. And I have read many cases where another person testified that the defendant was there and that he heard these words. So I'm going to let it in on that exception. And then that will obviously be an issue for the jury. Thank you. All right, next up.
I'm not totally sure where we are. Is it my motion in limiting 11?
Well, just a second. We did the crew letter. I don't know how that happened.
I don't think we did do the crew letter. We didn't.
Oh, we didn't do it. Just a minute. All right.
We have the other as well.
Right. Yes. Okay. Thank you. D1. All right. Let's do the crew letter.
So there's a letter written by, well, signed. I think Therese Davis wrote it, but I'm not 100% sure. I'm not 100% sure who wrote it, but there is a letter. There was.
Yeah. Okay, sorry. I'm fine. In my mind, I was thinking the Crow, but yes, I'm ready to
Okay.
do the Crew.
Okay, great. So I don't know exactly who wrote this letter, but I think maybe 24 or 25 of the crew members signed it. Only 2 of the crew members who signed it were in the church at the time of the shooting, and the letter basically says this was a safe movie set. But let's forget about the fact that a human being died and another one got shot. So they get about 1/6 of the crew to sign this letter. The other 5/6 of the crew apparently declined to sign this letter. It isn't something that I recall being signed by Mr. Baldwin. And there are only, off of memory, I think 2 witnesses who signed the letter who may testify in the trial. So what I don't want to get into is we've got a witness on the witness stand who's giving testimony about what they saw, what they heard, all of the relevant testimony, and then all of a sudden they get asked, and isn't it true that you and 25 others signed this letter saying that the set was safe? That obviously doesn't come in. That's hearsay all day long. And I'm looking at the defendant's response. The state's assertion fails to note that Baldwin's prior statements can be introduced by the defense to rebut a charge of recent fabrication. I don't know. I have struggled. This is in the last paragraph of the defense response. I don't really know what they mean because Baldwin, I don't think, wrote the letter and he didn't sign the letter. So I'm not sure what this letter would have to do with his prior statements to rebut a charge of recent fabrication. The defense has also indicated if a witness testifies in a manner that is inconsistent with the letter's contents, or if a witness raises the crew's position about issues raised in the letter, then the letter may be admissible. I disagree. It's a letter that is completely irrelevant. Not only is it completely irrelevant, it's absurd. As the defense has indicated, people hardly ever get killed on movie sets. So for a person to get killed on a movie set kind of inherently means it was a pretty unsafe set. So I filed this out of an abundance of caution. I was actually kind of anticipating when I filed it that the defense would say, we agree, we're not intending to introduce the crew letter, but apparently they'd like to try to get into it somehow. And I just want the court to be aware we've got major hearsay problems here. Thank you.
Thank you.
Your Honor, this is one of those evidentiary issues that should really wait for the context in which it comes up or not. And the reason is this. You already heard the state say, we're going to put on the medic to say, I believe the set was safe, or the camera grip to say this was a safe set or not a safe set. To the extent any witness they put up says, the whole crew thought this set was unsafe, or they signed the crew letter and they get up and testify that it was an unsafe set, contrary to what they signed in the letter. We're not offering the letter to prove the set was safe. That would be the use that would not qualify under any hearsay exception, because we'd be using it to prove the truth of what's said in it. To the extent it comes up and we use it, it's only to demonstrate that a witness testifies inconsistently with what they signed, or their statement that the whole crew thought this was an unsafe set is inconsistent with what other crew members said in that letter. Not for the truth, but for inconsistency, for example, for impeachment, for example. And so the circumstances in which this come up could make it inadmissible, in which case we wouldn't use it to prove the truth. Or it could be highly relevant to what the crew member who signed it is now saying on the stand, and to be denied the opportunity to confront somebody who signed that statement, for example, who says something directly contrary to it, to not be able to put that in front of them to say, well, what you're saying conflicts with what's in this document. That's not hearsay. That's admissible. It goes directly to the testimony they are given. Second point, the Baldwin statements issue. The state said in its brief, and by the way, in this brief, Baldwin statements shouldn't be offered by the defense. Now, we have no idea what that means in the state's brief. Our point was, if we're going to offer his statements or if they are, you have to wait and see the context in which that arises. We were just trying to preserve any right we have to argue that in one situation or another, the statement should come in or not come in. But I don't think there's a ripe issue for Your Honor to rule upon. We were just reacting to the state's one sentence in its brief, which we didn't understand. So out of an abundance of caution, we wanted to make the point that we're not waiving any rights on that. But I don't think there's a ripe issue for Your Honor to rule upon with respect to Mr. Baldwin's statements. Thank you.
I apologize. I was confused. I get it now. So I think we're agreeing generally, absent something unforeseen, that the crew letter doesn't come in as substantive evidence. So we'll deal with any outlying issues should they arise. The defendant's statements, if offered by the defendant, are inadmissible hearsay under 11-801 as the party opponent. He is not his own party opponent. So I can introduce his statements because he's my party opponent. He doesn't get to introduce his own statements because they're hearsay. So I just wanted to have some record generally that the defense doesn't get to start bringing in the defendant's statements through other witnesses. That's all it is. And I'll make my objections appropriately during trial.
That's it. We're done. Thank you. All right. The court rules as follows. The crew letter is an out-of-court statement expected to be offered for the truth of the matter asserted, and as such will be excluded based on hearsay. It could not be used as a prior and consistent statement unless the testifying witness participated in the letter and the foundation is laid. It cannot be used for impeachment otherwise because what the witness testifies to about the conditions on the set is his or her testimony. The defendant would have to bring in a witness to state otherwise, not use this out-of-court statement to impeach the testifying witness. To do so would be an end round against the prohibition against hearsay. I think we're all in agreement. It just seems like we all said the same thing. Okay. Thank you. So that's granted today. All right, let's get back to the Crow. The Crow letter. No, it wasn't the Crow letter. It was inconsistent factual assertions. Yes.
As Your Honor knows, we cited multiple cases in our briefs saying that the government is a party opponent or allowed to introduce statements that they've made if they're inconsistent. It's black letter law in a number of cases. In fact, the state's brief acknowledges that it's black letter law. Your Honor mentioned the Montoya decision. I've read that, and this is consistent with our position, Your Honor. In that case, the prosecutor said an opening statement to the jury, you are going to hear a witness testify that that witness heard another person say X. The second trial, the defendant said, I want to introduce the prosecutor's statement in the opening as an inconsistent statement in this trial. And the court said, well, you're not allowed to do that because it's not an inconsistent statement. It's the prosecutor saying what the jury should expect to hear from someone say about what someone else said, double hearsay. And the court said, and this is really important, the prosecutor's opening statement to the jury was not an obvious admission of fact that might have constituted an admission of a party opponent. In other words, if it were, we'd admit it because that's black letter law, but it's not. It's a prosecutor giving a sort of preview, not making an assertion factually, and therefore it's not a party opponent admission. It doesn't come in. Here, the statements that we are intending to use are not comments on what the jury might hear from a witness who talks about another witness's statements. These are statements that are clear, direct. Ms. Gutierrez-Reed's training of Mr. Baldwin would not have made a difference. Now they want to come in potentially in this trial and say, if Mr. Baldwin just did the gun training, it would have made a big difference. That is a direct inconsistency. It's not a comment about what a witness might testify about another witness's statement. The same thing is true about Ms. Morrissey's statement that Hannah Gutierrez-Reed is the autonomous decision maker, and so forth and so on. We've listed a number of these statements in the brief. These are direct factual assertions by the state in the prior case. The black letter law is that that's a party admission, party opponent admission, and therefore it comes in. The Montoya case is consistent with that, and therefore I believe it supports our position that we should be able to introduce this at this trial. And that's, again, consistent with what the state told Your Honor to rely upon it in Justice Thomas's concurrence. If the prosecutor wants to make those statements, that's fine, but there's a risk of undermining the prosecution's case because the second defendant has every right to present them to the fact finder as contradictions. That's from their own case. And that's exactly what we're asking the court to allow us to do here. Thank you, Your Honor. And unless you have questions about the Montoya case. Thank you.
Is this a defense or a state?
It's a defense.
Which number is it?
I believe it was defendant's motion on limine number 5.
Number 5?
I believe so.
Okay, all right, go ahead.
Your Honor, I would respectfully submit that the defense is narrowly reading Montoya. So you have 2 different trials of 2 different defendants. So the prosecution can say X in trial of defendant 1 with the facts that are available and still present a different argument with the same set of facts, but as to defendant number 2. And so the statements made by Ms. Morrissey during her arguments to the jury in Gutierrez applied to Gutierrez, applied to her culpability. That doesn't mean that the state should be bound or that the defense gets to introduce her statements to the jury in Gutierrez because they pertain to Gutierrez. This is a different defendant. And so the facts are they're still the same well of facts, but the facts that we're drawing upon for this defendant are slightly different than the facts on Gutierrez. And more importantly, even if the court were to find that, well, okay, statements by a prosecutor are admissions by a party opponent, the court still has to subject that decision to a Rule 403 analysis. And under Rule 403, allowing the defense to introduce the statements Ms. Morrissey made out of context, so they're picking and choosing specific statements they want to introduce, would create confusion to the jury. It would be misleading to the jury. So the statement that counsel indicated that Ms. Morrissey made about Ms. Gutierrez being the autonomous individual, that pertained to Ms. Morrissey's argument as it related to ammunition. With regard to another statement that Ms. Gutierrez was not rushed, but yet in this trial, one of the issues is the defendant rushed Ms. Gutierrez. She was not rushed that particular day on October 21st, but rushed on other days to reload the firearm. So these would be completely taken out of context, Your Honor, and the court has the discretion to not allow these statements to be introduced as admissions by a party opponent. And I think that Montoya does apply because these are arguments by counsel that the court should exclude at a minimum under Rule 403. Thank you.
Just a couple minor points, Your Honor. The case law is not distinguishable because that was a defendant in one case, and then there's a defendant in a second case. That's the only situation in which the party opponent admission rule comes up. Every single time a defendant in the second case says, I want to have the fact finder consider the contradictions that were said in the first trial, and the court said, yes, you're allowed to do that. That's a party admission. Every single one of those cases involved 2 different defendants. And so trying to distinguish this case by saying, well, that's Hannah Gutierrez and this is Mr. Baldwin. There's not a single case where a party admission was allowed in this context where that wasn't the case, two different defendants. That's what the case law stands for. The element of confusion that the state is relying upon, they're saying, well, you have to balance 403. Every single case, black letter law, party opponent admission comes in, as long as it's not, hearsay upon hearsay upon hearsay, where a prosecutor saying this is what to expect. That's not an admission. It's admissible. And so these 403 balancing was in play every single one of these black letter law cases where the court said it gets admitted. And as Your Honor knows, 403 is an extraordinary remedy. So to apply 403 balancing and say it'd be too prejudicial when the black letter law says, as a matter of law, it's not because you're allowed to introduce it, there's no case to support that, Your Honor. The statement should be allowed.
Thank you. The court denies the defendant's motion. This is an issue that the court has discretion on. I'm not mandated to put it in. I have the discretion on whether to put it in. First of all, I don't think that what the prosecutor said in Hannah Gutierrez's case is relevant to a relevant fact. And even if it is a relevant fact, its probative value is substantially outweighed by unfair prejudice and confusion to the jury. In addition, I don't think the theories are inconsistent, but a continuum. Hannah Gutierrez loaded the weapon with live ammunition. Defendant Baldwin took that weapon with live ammunition and, according to the state, failing to follow firearm safety as an actor on the set of Russ, which continued into October 21, committed involuntary manslaughter as well. So I don't see it as inconsistent theories or inconsistent fact assertions, maybe separately hanging out there in one sentence, but I'm denying the motion. All right, next up is the Pieta. Defendant Alec Baldwin's motion in limine to preclude improper opinion and testimony from Alessandro Pieta.
Thank you, Your Honor. The state intends to offer Mr. Pieta for two general opinions, maybe many subcategories, but to sum it up, two. One, according to the state's brief, that the gun appeared to have been broken when it was in full cock position. And number two, the quality control standards that Pieta applies, the strength of the steel of the gun, and the overall condition of the gun when it left the Pieta factory. And they intend to do that because, according to their opening of the brief, to show the functionality of the gun on October 21st. But if you look at the actual trip this gun took after it left Pieta's factory, it went through a show, it went to a distributor, it went to Seth Kenny, and it went to this set. Mr. Pieta hadn't seen the gun leading up to his PTI for 7 years. He had no idea what happened to it. He had no idea if it was modified or not. He didn't inspect the gun. He didn't review the gun reports. He barely knew what happened in this case other than there was an accident with the gun. And so to allow him to testify about the circumstances under which the gun appears to be broken when he hasn't inspected the gun itself or looked at the reports or done any testing is improper testimony by someone who has not relied upon any information that an expert would need to rely upon to give that kind of opinion. First off. Second of all, the quality of the gun when it left, the steel strength when it left, has no bearing on 7 years later, or 4 years later when the accident occurred, what the condition of the gun was. The testimony that Mr. Pieta might offer on that could be wildly misconstrued by a jury, highly prejudicial, because it was hard steel and it was made with quality on December of 2017. Therefore, the gun was in perfectly working condition in 2021. There's an enormous gap there, Your Honor. And to offer that testimony from 2017, after so many things happened to that gun, as to the condition in 2021, is more prejudicial than probative. Thank you, Your Honor.
we have a made up defense of the gun was modified, the gun wasn't functioning properly. There's not a single witness who is going to support that. Not a single witness, including the defendant himself. Yet, the defense is going to be put forth. If I don't call Mr. Pieta, we're going to find ourselves in closing arguments, and the defense is going to say to the jury, you don't know how this gun was manufactured. Maybe there was a mistake. You don't have any idea what condition it was when it left Italy. It could have left Italy in this condition, and then it made it to EMF, and then it made it to Mr. Kinney, and then it made it into poor Mr. Baldwin's hands, and it malfunctioned. That's what they're going to do. I can't let them, so I am bringing the man who owns the manufacturing company to testify. Moreover, if the court recalls from our response, this is a conversation that Mr. Nickus and I had back right around the time that I initially dismissed against Mr. Baldwin, where Mr. Nickus said, this shiny hammer, the color of the metal doesn't match the metal on the rest of the gun. We think this is a modification. So then we get Mr. Pieta to come in because we want to know, is this a modification? Mr. Pieta says, heavens no. He says, I picked out that shiny hammer because we decided that we were going to make this gun look more like a Colt so that it could be used in gun shows. That's the purpose of his testimony, and it goes directly to their defense.
I have a question.
Sure.
It says, Mr. Pieta, you've talked about the parts did not leave Italy in their current condition and will testify to what Mr. Pieta can testify that the broken parts of the gun are Pieta parts. The parts did not leave Italy in that condition and will testify to what parts are broken. Mr. Pieta can also testify based on his knowledge of the parts and the internal working mechanism of the gun that the hammer, sear, and bolt appeared to be damaged when the gun was in the full cock position.
He said that during his pretrial interview.
I didn't see that.
He said it I think he said it in his pretrial interview under questioning from the defense let me look for it in his transcript if you want me to. I can do a quick word search on his transcript. Under questioning, he indicated that from looking at it, he could tell that it was, because he's Italian, I don't know that he used necessarily, I think he said it was in the firing position. I don't think he used full cock, and I think that was part of the language barrier. Do you want me to see if he said it in his, I can pull it up for you.
That's all right.
Okay.
Two things, Your Honor. That's exactly the concern we have about Mr. Pieta. He hasn't inspected the gun, hasn't reviewed the gun reports. To look at a picture of a gun he saw 7 years ago and to say, I think the damage occurred this way, that is not reliable expert testimony. He hasn't inspected it. He has no idea the conditions under which it was used, the conditions of the FBI testing. He hadn't even heard the FBI tested it, didn't know what was done. And so for him to give an opinion on what caused the damage, highly unreliable, no basis whatsoever demonstrated. He has no facts about that. And it would be hugely prejudicial to admit it, number one. Number two, there's no evidence in this case that the gun left the factory broken, that it was modified with the hammer at the factory. The testimony that you heard from the Haigs, for example, about the FBI testing is whether the FBI broke it or not, whether it was modified beforehand by Seth Kenney. No one thinks that it left the Pieta factory with a hammer ground down or sideways marks on the sear. That's not at all an issue in this case. And again, since it's not at all an issue in this case, it would be prejudicial for Mr. Pieta to come in and say, we make very strong guns. We make guns that are quality guns, to give the impression to the jury that, well, this must have been a functioning gun in 2021, because in 2017, after long before many, many things happened to it, it was a strong functioning gun. That's unreliable. That's prejudicial. It's far too far away from the circumstances of 2021 to be admissible.
The court makes the following ruling. The court finds that Mr. Pieta is properly a fact witness. He's not an expert witness. He can testify to his knowledge of the gun before it left the factory, he can say it was a functioning gun if he tested it at that time. I think that you want the court to follow down the meander of strong functioning gun. He's not going to say strong. He's going to say that it was functioning, and I think that the creation or origination of that gun, for purposes of what Ms. Morrissey said, that so that in closing it's quelled with respect to where's, in so many words, how do we know it was looking good when it got manufactured? So he comes in, but his testimony is going to end to his knowledge of when it left the factory. He can't testify. He just learned that it was broken by somebody told him the FBI broke it, and all he can say is, yeah, it's broken.
Understood. And just so that I can structure his testimony within the court's ruling, I won't have Mr. Pietta give any opinion on whether or not what position the gun was in when it was broken or anything like that. I would like to have him, if he can, because we're going to have the gun and the parts here in the courtroom prior to his testimony. I would like to show them to him and see if he can identify, yes, these are the original parts. If he can, I don't know. And in addition to that, part of his testimony that the gun left his plant in good working condition has to do with the quality control measures that they institute within his manufacturing plant, so they don't have guns that leave that then go malfunction. So a little bit of testimony about quality control, I would ask the court for a little leeway there, but I understand the ruling. We won't have him talk about his thoughts on how the gun got damaged.
Thank you. All right, is there anything else? State. Did I cover everything so that we're ready for jury selection and trial?
I believe we are, if the court wants to take a few moments to address my concern with the exhibits.
I thought you all were going to work on the exhibits.
Well, I've got some concerns based on the looks of their exhibit list that a meet and confer isn't going to resolve this issue.
We have a couple concerns of our own with some exhibits that were just disclosed yesterday.
Well, give me a copy if you want, because this will be the first time I'm seeing them. So
There is also a defense motion to compel that was fully briefed over the weekend. If the court is willing to consider that today, we can address it.
no, I'm not. Why are you writing documents and then not giving to me and then or her? What do you mean? The motion to compel? Oh, you mean the big motion to compel?
Yes, there is a motion to compel that was just finally.
You can make arguments on that, but I'm not going to rule from the bench. If you want to do that, do you want to do that?
It's their motion, sure. Ms. Johnson's responding to it.
Okay. Go ahead. You didn't do a notice of completion of briefing, but okay.
You did submit it, Your Honor, but I can
Okay,
resend
that's
it.
fine.
So, Your Honor, I know that this is unfortunately something that we've brought to the court on more than one occasion, and I know that this is not the time that the court would prefer to hear these issues. However, precisely because we are at the eve of trial is why we have to bring this up to the court again. As the court knows, under the laws of New Mexico, the state has an affirmative duty of production, both under the rules being 5501 and also under Brady, Giglio, and all of those. So it's been apparent from early on in the case that we were not receiving all of the productive documents and discovery that we should have been receiving. We've detailed in our motion the numerous attempts that we've made to try to address those concerns. They were not addressed at any point. And I'm going to focus on the reply that we did submit to the court because the circumstances have now changed to some degree in a fairly material way. And that is that initially we had been corresponding largely with Ms. Morrissey, who had been the prosecutor on this case for quite some time before Ms. Johnson came on. Our requests for production and our concerns about it looking like we had incomplete discovery, like it looked like we had incomplete disclosures. We're constantly met with, you have everything, there's nothing else to give you, or if you tell me specifically what you're looking for out of these, IPRA productions that are redacted, tell me specifically what it is that you want unredacted, and then I'll take a look. The problem with that approach, Your Honor, is that the state, again, has an affirmative duty. It's not a reactive duty. It's not that the defense has to first try to guess at where there might be additional discovery that we're entitled to, what Brady information might be out there. The state has a duty to take it upon themselves to review the documents and the discovery in their possession and to turn over anything that falls under 5501 or their other affirmative disclosure obligations under Brady, Giglio, and their progeny. So what we did was, realizing that we were getting nowhere, again, after all of these months, we had dealt with IPRA to try to take it upon ourselves, even though it's not our obligation, to try to get more documents. Those came in over the course of about 7 months, again, heavily redacted. And we could tell that there were some documents that certainly appeared to have the type of content that we would be entitled to. But many, many of them had entire sections that were just completely blocked out. So we don't know what the content was at all. We could only see, who the sender and recipient were. And everything was blocked out. So we were left to guess, whereas the state has the affirmative duty of disclosure. And so what we did was then we, for the first time, I believe it was on the 27th of June, reached out, and instead of emailing both prosecutors or just Ms. Morrissey, we reached out directly to Ms. Johnson and only to Ms. Johnson. And basically, under her obligations as a prosecutor now on this case, asked her to fulfill those obligations and do an affirmative review of everything and to turn over anything that needed to be turned over. The same day, in accordance with her responsibilities, she did then respond and said that she was requesting a full unredacted copy of the thousands of documents that we received under IPRA that were still redacted, and that she would undertake an affirmative review of those items, as well as checking for an audit with the law enforcement agency. That same day, after she responded to us with the request that we had just sent her, again earlier in the same day, we started to already get disclosures where Ms. Johnson was saying, I've found documents that are subject to disclosure under Rule 5501, contrary to what we had been told from the inception of this case, which was that we had everything that fit under 5501. It was repeatedly told to us, you have everything, you have everything. Yet we received production after production after production, totaling over 1,100 pages from Ms. Johnson over the course of June 27th to June 29th. And in each of these multiple disclosures with numerous Dropbox links, we received disclosures from Ms. Johnson where she indicated, here are documents that are subject to our obligations under Rule 5501, documents that we had never seen before, despite the fact that these documents were not just in existence as soon as June, they had been in existence for months, over a year even sometimes. And we have a number of them, Your Honor, that I will go over. And so these are the types of documents that were withheld. So we have, for example, there were documents that were created on January 23rd, 2023. They were not disclosed until June 28th, 2024. The topic of those documents, and I have them under an exhibit, which actually I believe is attached to our reply, that would be Exhibit N, is comments on whether or not it's customary for actors to be shown what was in the gun. Again, a central theory of the state's case, that actors are supposed to be shown the contents of the gun so that they can check whether or not there's a live bullet or a blank or a dummy. And so those were comments with witnesses to this case, and that's Exhibit N that the court can look at. And I do have an extra copy if the court needs an additional copy. Okay, yes, Your Honor. And so we've tabbed them, Your Honor, so that the court can look at the exhibits that we have there. And so, so Exhibit N is what I was just referring to. And again, that the date of that statement that had been withheld was January 23rd, 2023, almost a year and a half ago. We also have another statement that was withheld November 17th, 2022. That was just disclosed June 28th, 2024. This is Exhibit O. And the topic of this is the benefits and requirements of New Mexico tax incentives. That's the production that was at issue in that one. And again, it's Exhibit O. Another date of withheld statements, December 11th, 2022. Date of disclosure, June 28th, 2024. In this one, these are opinions from the state's own expert, Brian Carpenter, about statements that were made by Hannah Gutierrez-Reed, and this is Exhibit P. So they had these statements and opinions from their expert, Brian Carpenter, since December 11th, 2022, and we did not receive it until June 28th, 2024. Additionally, Your Honor, again, December 11th, 2022, statements from Brian Carpenter, the state's expert, understanding of what happened on the set of Rust and including in the church. That's his own understanding based on what he had looked over. Clearly a statement by their expert. The date of disclosure was not until June 28th of this year. August 21st, 2023 was the date of another statement that had to do with the topic was whether or not shooting lots of blanks might impact the fire control components of a firearm. This is Exhibit L and was with the state's firearms expert being Lucian Haig. And so this is again another statement by yet another state's expert. We did not receive that until June 29th, 2024, despite the fact that they had it since August of 2023. Then we have additional statements from November 10th of 2023 and April 19th of 2023. And these were more states' expert witnesses, the Haigs, opinions related to Mr. Baldwin's handling of the firearm. This is Exhibit L at 2 and 3. The list could go on, Your Honor, but again, we just received these disclosures as we're in the middle of trial preparation on the eve of trial. But we have received, again, over 1,100 documents, and we are doing our best to comb through these to pick out what we have. These are just some of the ones that we've been able to pull out thus far. And these are just the ones that we've received within the last week. As the court knows, this is not the first time that we've been made aware that we were not getting disclosures timely. We had the Haig report that was initially disclosed on August 20th, or that was written on August 26, 2023. We didn't get it to April 29th, 2024. And again, the prejudice for these is we got that after the pretrial interview was already conducted, 1 week before the dispositive motion deadline, and a week before the witness deadline. The third Haig report for August 31st, 2023 was not turned over until May 21st of 2024. And again, this is after the pretrial interview was conducted with the expert, after the dispositive motion deadline, and after the witness list deadline. And the list goes on and on and on and on. We have so many of these, Your Honor. And the problem with this is, the state talked in the beginning, one of the first motions that they referenced, they were talking about there are rules, there are deadlines that are set in place that the parties are supposed to follow. Absolutely. And these are rules that are very clearly intended to ensure that the defendant has his due process rights fulfilled, that he has the right to a fair trial, that he has the right to present a defense, and that he has the right to confront the witnesses against him and be prepared with any statements that those witnesses have made so that he can explore in discovery, so that he can determine whether or not he would call other witnesses, so that he can ask these witnesses about the statements and opinions that they have given, and so that we can actually do something with it, rather than receiving these now a week before we are set to go to trial on a case involving a manslaughter. And so, Your Honor, at this point, it is, and I know the court has heard us say this before, and the problem is we've had to say it repeatedly because of the continuing violations, is that it's not something that the court can turn a blind eye to. It's egregious. It's been repeated. It's been throughout the duration of this entire case. And all we've been trying to do is get information that we have been entitled to from day one, or from day 10, I guess, if we're going 10 days after the date of arraignment. But there was always a continuing duty to disclose that whenever they received something new, within 7 days of that receipt, they would turn it over to us. And this has not happened throughout the pendency of this trial. Even now, even though Ms. Johnson has gone through and has reviewed and taken it upon herself to do some of this, there was nothing preventing her from doing it earlier. But it wasn't until we reached out to her directly that she finally waited and wasn't just waiting for Ms. Morrissey to respond. She did take that duty upon herself. She should have done it earlier, but she did do it, and we appreciate that. But even now, there are still documents that are redacted that we know contain statements that we are entitled to, that we still don't have the redactions lifted for. And I have examples here for the court that I can show if I may approach. So what I've handed the court, Your Honor, are, again, and these are just things that we're having to affirmatively comb through now on the eve of trial. One that I've handed to the court, if the court will look at, is dated Wednesday, January 18th, 2023. It's a communication from Brian Carpenter, the state's expert. And it says, attachments, statement of PC, being probable cause, Baldwin, with BWC markup comments. This is, we assume, again, Brian Carpenter markup comments. So he's reviewed the statement of probable cause, and this is back in 2023, and marked it up with whether or not he felt that the statement of probable cause was appropriate, was whether or not there were any problems with it. And this is just what we have to assume, because he says he marked it up, meaning that there were changes that he made. So these are clearly statements and opinions by this expert, and yet is entirely redacted still. We can see nothing about it. We see team up at the top and nothing else. So we still don't have his statements as to, and comments as to the probable cause. In addition, number two, we have the one that starts on March 6th, 2023. And in this one, it starts with the big blocked out section at the top of the page. And it's from Jennifer Paget Macias. And she indicates, good morning. We need to disclose the email below in discovery. But before we do, we need to get subpoenas and certificates of compliance out for specific documents. She then goes on to say a number of different things. This has been identified as something that should have been turned over in discovery. And yet if the court flips through it and she says, you know, what follows is supposed to be disclosed, it's nothing but blackened pages. We have none of the contents of these communications, despite the acknowledgement by the prosecutor in that case, that was subject to disclosure. We then also have additional documents. Another one from Jennifer Paget Macias, dated February 20th, 2023, where there are attachments. And this is an inquiry to Brian Carpenter from Ms. Macias, where she is asking him whether or not he can look through some documents, these safety bulletins, and let her know if their expert, Brian Carpenter, is familiar with the guidelines, if he has experience following the guidelines, and whether those would have been applicable to the rust production in New Mexico. She says, in other words, do you have personal knowledge as to these standards? Certainly his answer to that is relevant to his qualifications and whether or not he is appropriately an expert. If he has no experience or very little experience with these things that are directly at issue in this case, then he certainly doesn't make an appropriate expert. but we do not know the content of these communications. We don't know what Mr. Carpenter said about whether or not he was qualified because it's entirely blacked out. We have nothing that we can see from this. And in addition, Your Honor, the last one, again, is messages between Mr. Carpenter and Ms. Morrissey. These have been blacked out. We have, some just kind of initial back and forth. Presumably, if that's all it was, there would not be further redactions, and yet there are. So here we are on the eve of trial. We still don't have these documents that we clearly have a right to have. And again, on document number 2, actually, I believe there's a portion on the 3rd page where it's like almost completely blacked out. But if you look at the portion, you can kind of see part of the sentence, like half of the word, and it seems to say something about script supervisor and continuity supervisor. That would presumably be Mamie Mitchell, who is a witness in this case and was in Ms. Gutierrez's case. Something about required her to keep something, costume, and something details. But we can see that it's about one of the witnesses who actually has testified in Ms. Gutierrez's case and will be a witness in this one. And again, it was identified as something that is appropriate for disclosure. So we are here late in the game, and this is not where we want to be. I know this isn't where the court wants to be, but here we are. And it's not through any lack of trying on the part of the defense. It's just that we have been dealing with a situation where we cannot get appropriate discovery. And this is not how it's supposed to work. And so what we are asking the court to do is to recognize that in this case, there have been significant and substantial violations. And in cases where there are egregious discovery violations, dismissal can be an appropriate remedy. Suppression can be an appropriate remedy. And while we would argue for dismissal, we know that the court is not inclined to do that at this stage, but in this type of case, it would be an appropriate remedy, and it is one that is available to the court. If the court were not to grant a motion for a dismissal, however, there are other remedies that the court can also entertain, and the court should entertain, because when we're looking at the kinds of violations like we've seen in this case, it has materially impacted the defendant's ability to be able to prepare for trial, to be able to interview the witnesses, to be able to seek out its own experts and do whatever it is that we need to do in the case when there have been so many continual discovery violations. So the more narrowly tailored remedy that the court could fashion, even though it would not put us completely in the position that we would be otherwise, the closest that we could probably get is if the court were to look at these topics for which we still have these disclosure issues, for which they've now just disclosed these things from their expert witnesses, again, the week before trial when they've had some of these for over a year, and say, I see that there is prejudice, I see that there were violations, and there's prejudice to the defense. So we will not allow the state to benefit or to put on these topics of evidence because the defense is not in the position that they would have been had these documents, had this discovery been disclosed in the timely manner that they were supposed to be. And frankly, while we still want disclosure now, and we are asking that the court lift the redactions and ask for an in-camera review of the documents that we've provided as the exhibits that we still have that are redacted, that we don't have the ability to see the contents of, we would ask that the court lift those redactions so that we can see what's in there. But there is nothing that can cure the fact that these things have been disclosed so late in the day that there's not much we can do with them. So we are asking that those topics that I've outlined in exhibits N, O, P, and L, that the state not be permitted to introduce evidence or testimony related to those topics, since we are at a disadvantage because of their withholding of this information. And we would also ask that, similar to the other motion that we had done where the court ordered that the jury would be informed of the violation with respect to the Hague report, for example, we're asking that the court allow us to submit a similar instruction with respect to their violations in this instance, so that the jury can know and actually draw their own inference that this information would have been helpful to the defense had they been able to see it.
So you're asking me for 4 solutions. One is to dismiss the case. The second is to eliminate subject matter The third one is that, which is ongoing, is for them to keep going, keep looking. And then the last one is,
The inference instruction.
what you're asking for is a continuance. So why don't you come out and say it? Because you don't want one.
We
How
don't,
are
that's
they
correct.
going to keep looking for things without a continuance?
What we're asking, Your Honor, for right now is those specific documents
No,
that I
you're
provided to
asking
the
for
court.
4 things, okay? And I'm asking you, how is that not going to help if I don't give you a continuance? You are essentially asking for a continuance because you're saying they have to keep looking. We have 8 days of trial and they have to keep doing this. What does that mean? How does that compute?
So, Your Honor, so what we're asking for is not actually a continuance, and we're not even asking for those extended things. What we're asking for is we've identified a discrete number of documents right
Well,
now.
You've got to adjust your request then.
Okay, Your
What
Honor,
is
so
it?
let me try to do that then. So what we've handed to the court is a number of documents that still remain redacted. We cannot see the contents, is what we've provided to the court. We're asking that the court lift those redactions or order that the state lift those redactions so that we can see what those are, because those are clearly discoverable and yet we still don't have the contents. That's one request that we're making. The other request is related to exclusion of subject matter, and that's because we don't want a continuance. We don't want a
What is the
continuance.
subject matter you want?
The subject matter, Your Honor, that we're asking the court to not permit are those subjects that are included in those exhibits that I just detailed for the court. And so that would be, and so, Your Honor, what we would like to do at this point, because we understand, again, this is a difficult position. It's difficult for us. It's not where we want to be. It's difficult for the court because here we are at the eve of trial. We don't want a continuance. The court has already ordered us to meet and confer. My understanding actually from Mr. Spiro is that the state had indicated to him, I guess a moment ago before we argued this, that they have some additional disclosures that they would be making. I don't know if that includes potentially what we're asking for with respect to lifting of those redactions. I'm not sure what that involves. I wasn't part of the conversation. So we may be able to get something out of a meet and confer where some of the remedies that we're seeking may already be addressed. So if the court would allow us to do that meet and confer, then perhaps we can bring this again before the court once we know what situation we're in currently.
Thank you. State.
Thank you, Your Honor. Your Honor, first, as the court knows, I'm somewhat newer to this particular case, but the state has complied. I did receive the request, and Ms. Morrissey didn't have the unredacted IPRA. I requested the unredacted IPRA. We went through all of those documents and made those disclosures. They have the information, and the information that they want is information they're not entitled to. So they received information that was subject to disclosure under 5501A6, 5501G, and these are emails is what we're talking about. They're emails with witnesses. And just to give you an example, Judge, I brought the unredacted, and I'd like to give it to the court for an in-camera inspection, and you will see they're not entitled to it. They're not entitled to that information because it's not statements from witness. For example, the email where Ms. Paget says, we have to disclose this. Well, it's actually the contents of what the person, it's a paralegal emailing the DA's office. That's not a witness statement. And it's just basically saying, hey, we need to get these things and they need to be disclosed. So if the court would like to take a look at it, Your Honor, for an in-camera inspection, if I may. Well, no, no, Your Honor, because it's for an in-camera inspection, just for the court. So it's the last page, Your Honor, where it begins after Ms. Paget signs, thanks, Jennifer. It's a very second to the last page. You'll see it's an email from a paralegal at a law firm. They're not entitled to that. What the defense is complaining about is they want communications between the attorneys. They want communications between paralegals and the attorneys. They're not entitled to that. They're not entitled to our strategy. They're entitled to witness
How
statements.
would they know that? Why can't you tell them they're not entitled to this?
I did.
Because
I did, Your Honor. I went through and I disclosed numerous disclosures. And I specifically in those emails stated, and they attach them as exhibits, these are being disclosed because they were found to contain information that is subject to disclosure. So if it's still redacted, it's not subject to disclosure. And so the other documents, Your Honor, I'm happy to submit those to the court for an in-camera inspection.
I'm not going to do an in-camera inspection. I'm ready for trial,
Yes, Your Honor.
okay?
And I understand. And what I'm telling you as an officer of the court, as a representative of the state, I went through these.
Why so late?
Your Honor, I was requested on June 27th to do, because
Well, I'm asking the state in general.
Miss Morrissey didn't have a copy of the unredacted IPRA, Your Honor. So a lot of these happened
Why did you
before.
give them IPRA?
Well, what happened was the defense requested an IPRA in October of 2023. Mr.
Well, you
Baldwin.
knew what was going to happen with that. Balloon.
Yes, and Mr. Baldwin wasn't charged at the time. So that when they received the production from the state, he was then at that point charged. I believe it was in May. They asked Miss Morrissey, would you please unredact? Well, it was thousands, as you noted. Miss Morrissey asked, tell me which ones you want unredacted and I'll take a look at them. She received no
This is
response.
all about the IPRA. Is this correct?
Yes, it
This is all
is.
about the IPRA.
It is.
This isn't about any other discovery that was disclosed except what was disclosed in the IPRA.
Yes, and they're witness statements. That's what it is. So a proper remedy, Your Honor, under Harper is a continuance. It's a continuance. They have the information now. As far as the third Hague report, the court addressed that in the Brady motion. As far as this is concerned, they're statements. And the state has gone through, disclosed to what,
Have you already given them the statements?
that's what was unredacted. That's what we went through and
Well,
unredacted.
what other redactions does she want?
She wants essentially what I just handed to the court.
In-camera, the ones that you said you can't do.
Exactly.
Well, you'd have to make, if they responded that this is privileged information, I can't do it for you. You're gonna have to make arguments on why the redacted portions of the IPRA request that she has kept redacted are fair game. And this is all about IPRA is what I'm understanding.
There's statements that were obtained, yes, Your Honor, emails. There are thousands of pages of emails. And so, Your Honor, the proper remedy, they haven't shown how they're prejudiced.
So obviously you can tell the court is not happy with this. We are in recess, go confer, and I'll see what's going to happen. I will give you an hour.
Thank you.
We're in recess.
Yes, Your Honor. I believe we've worked out many of the issues that were before the court, if I may quickly. So the state gave us the sense of their witness order,
Okay.
which showed us that the witnesses that involve these IPRA issues are the end of the case.
Okay.
So because of that representation, and they were helpful actually in just laying out the entire witness order, more or less. And so because of that, it gives us a little bit more time to meet and confer between ourselves. And the state's also willing to take a sampling of our IPRA issues. And we keep calling them IPRA, but just so the court understands, they are the normal discovery. They just came in and just read. So they're going to take them and look at them themselves in camera and give them a second look. And I'm hoping between the witness order and that, we will not burden the court further with this issue. In addition, I had held our opening motion in abeyance to meet and confer about the exhibits. The parties have reached an agreement as to the 8 or 9 exhibits each side is using, so that will not be an issue during opening statements.
Okay.
And finally, we were able to meet and confer about voir dire, and the state can correct me if I'm wrong, but one issue that you voir dired about in the last case that we think, at least I will.
Let me just go
Sure.
back up for a minute. So for the record, Ms. LeBlanc asked for 4 remedies. And I'm understanding that you have abandoned that request because, and you're satisfied with the compromise of witness order and that the state will take a sampling of IPRA issues in camera.
Yeah, we're holding, obviously, time will tell about the.
Well, that's not going to work for the court.
We expect that to resolve the issue. Obviously, we can always bring an issue back. As I said before, we don't intend to bring this back to the court. So I would say that it is mooted or held in abeyance for now. Obviously, they just gave us a Giglio disclosure, which was also helpful.
Well, what I'm trying to avoid
Yes.
is that this continues through the trial. And that's why I think a continuance would be the answer if it continues through the trial. And I want to do it now, obviously, if this is going to continue. So you all have to have resolved it.
Yes, it's my impression, based on the representations from the state, that they don't have any further disclosures, that they're willing to do this in camera in good faith, and that they're going to give us more advanced witness order notice than they would have necessarily been required to do. We believe that has resolved this issue.
All right. I would like an order regarding the motion.
Yes, Your Honor.
And I would like you to prepare it.
Yes, Your Honor.
Okay.
So can I just turn to that final quick issue?
Yeah, but if it's going to say being held in abeyance, I'm not going to sign it.
Yeah,
And I would like that tomorrow
yes, Your Honor. I won't use
before
the
the
word.
jury's sworn.
Understood, Your Honor.
All right.
The final issue that Your Honor raised before our original break today was the voir dire and how to run it, and
Yes.
any insight we had. The parties were able to confer on that too. And in the Hannah Gutierrez Reed case, you did the voir dire regarding guns.
I did?
I think so. I think you made that one of your questions to the panel. I could be wrong. I was.
I don't think so. I usually would not do that.
You would have to. Okay.
Yeah.
So that's just one topic that I think may be of the sensitivity and the type of topic that we may want the whole panel to hear and be able to approach on as a topic potentially.
I usually do not conduct any particular question other than what the UJI requires the judge to
Understood.
go through. And it usually stops on, is there any reason why you can't serve on this case? And then I turn it over to you for the specifics. So
Fair,
I don't, so
enough.
what do you say?
No, now I'm saying very little because you've just explained to me exactly
Oh,
how
okay.
my understanding had been that you addressed a couple of these issues yourself.
Of course, I
So-
could have, can't remember it too much. Okay.
And then the only other topic that we're going to raise is just the strong views on Mr. Baldwin in both directions that we're going to ask. We're going to be more eager to ask the court to take people individually on. But other than that, what the court had said made sense, and we have nothing further.
Well, so are you going to ask to speak in private? I'm not sure on what you plan to do on that.
Well, I think that if people have very strong views, if somebody indicates very strong views on Mr. Baldwin, that is the type of topic that I think has the potential to taint the jury pool as a whole.
Oh, so you mean come up to the bench?
Sure.
Okay, you mean come up to the bench
Yes.
versus what, are you going to speak in private? Because sometimes they don't stick around to speak in private. So you want it up at the bench? I just want to get the visual on this.
Yeah, I think that's what we had envisioned, that just, or frankly, if somebody has a very strong opinion on one of those two sort of, threshold issues, that if they raise their hand and indicate it, it's, thank you, juror number 14, for indicating you have a
Yes.
significant concern on this topic. We're going to come back to that juror then at a break, basically, is how I pictured it happening. And if the state pictured something different when we were discussing it, or if the court doesn't want to do it that way, of
No,
course.
but just so you know, how I've experienced this, when people want to share their views very strongly, they will keep raising their hand. They will meander back to what they really want to let you know, even if the question is not germane to that. And so if we say, do you want to speak in private? Sometimes they do not come back and speak in private. So you don't, you'll have to decide what to do with that. They come back for the selection, but they don't come back to speak in private. They don't stick around for speaking in private. So I don't know how you want to do that. I just don't want you to think here that people.
Yeah, obviously if they leave, they're not in the jury. And
No, they just don't speak in private, but then they come back. They don't leave like goodbye and not come back. So we'll take a recess and then we'll say, everybody that wants to speak in private, stay over there and we'll call you one at a time. And they just don't.
Now I realize why we're talking past each other. But so the way I've done it, especially in cases that have been heavily followed and there's media involved, is the court clerk or somebody will take, or I can take a roll call, and it'll be 14, 18, 19, 20. They go into the hallway and they say, jurors number 14, 18, 19, 20, please line up at the door during the recess. We speak to them each for 60 seconds during the recess, and then we're done.
Okay. Well, I hope that they do that for you.
Okay. We have nothing further, and thank you so much for the court's time today.
Okay. All right. We are in recess. So tomorrow, what you're going to do is you're going to come up here while we're waiting. Is that where did I get it wrong? Faith, somebody come out? Okay. So you're going to come up here and you're going to wait up here. And then when they say that the jury's ready for us, we'll all go downstairs together. Okay. Don't sit. In other words, do not go in there and sit. All right. Come up here. Yes.
Are you expecting that everyone be prepared to do openings tomorrow?
No, not at all.
Thank you.
We're going to pick a jury and then here. Okay. We're going to,
Downstairs.
what?
And we're meeting in Beach.
We are not here. Just the council.
I don't know if he's using our.
Why don't they just meet in here?
I just don't know if he was going to use our courtroom.
He's not going to be here.
We're officially switched courtrooms.
I know, but I do not believe, somebody told me he's not here. Huh?
Let me check.
Who told me that? Court TV said that. I'm just trying to get them not to have too many. Is it okay if you all go to the second floor in a new courtroom tomorrow while we're waiting?
Yes.
Okay. All right. It's a much bigger courtroom. All right. So 8:30, and then they'll typically call us around 9 to go downstairs. Okay. All right. Thank you. We're in recess. You can bring water and coffee with a lid. Okay.
Thank you, Judge.